to finalize with your address.
Yes, good morning, my lord.
Good to see you on your feet, yes.
We were 20 instead of 15 because we have two limbs of our submissions to be made by Christian Andole Matekwa and Tokua Lesinko. We had to take, my lord, will not exceed the 20 minutes even by a second, and if it reaches, you can just shut down our mic. They will share 10-10 each if it finds favor with you.
Okay, well, let's see. So what we propose to do after we finish with Mr. Morara and team is to hear the senior counsel. We have two senior counsel, Dr. Aminwa. Dr. Aminwa, I believe is here. And then we hear senior counsel, Ms. Mother Karua. And we propose Dr. Aminwa 30 minutes, senior counsel, Mother Karua 30 minutes. We propose to allocate Mr. Ongoya 30 minutes, Mr. Busiega 15 minutes. Sorry, Mr. Ongoya, I think it was 1 hour, sorry. Mr. Oluchir 45 minutes. Dr. Eboso 1 hour. Mr. Ochir Dudley 30 minutes. And the appellants, your 15 minutes. We have Mr. Kanjama's appeal that will come in the afternoon. We propose to allocate it 30 minutes. And then the reply to Mr. Kanjama's appeal about 30 minutes. Unless you have a different arrangement which you have made pursuant to the suggestion we made yesterday. But in the absence of that, this is what we are going to do. So this is Mr. Who?
With the court's permission.
Mr. President,
just hold on here, Senior Counsel.
It's on. With the court's permission, we actually had also caucused and we are pleading with the court.
Yes.
There are 6 of us. And we were 6 teams representing, there is Ongoya, whom you have mentioned, representing Justice and Isaac Ogola. There is Muhuri and Kituo cha Sheria, represented by Dr. Hamino. There is Alucher in Kasku. There is Dr. Muimali, represented by Dudley. And there is the 3 Amishi, Ambani, Musumba, and Ojwang, represented by me and Mudoni. And there is Kenya Human Rights. Kituo cha Sheria, I mistook the name. Dr. Hamino represents Kenya Human Rights Commission and Kituo cha Sheria. We were pleading that you consider giving us a little more time than the half an hour. Those of us who will finish before, we will not take the court's time. And we appreciate the court's wish to finish this case today, and it still can be finished. We are just pleading that the court be flexible, even if it means sitting into the evening to finish the matter, but to help us to have enough time to ventilate. Because we are here as respondents and we need time to ventilate.
Senior Counsel, I appreciate what you say, but to remember the so-called night sittings have become an issue in our jurisprudence, and we may not be able to go beyond 6.
We've sat before. In the Hunduma case, we were sitting beyond 8, and in many other cases, we would plead with the court.
I wish you knew the issues that have risen out of those so-called night sittings.
It's more propaganda than real issue. If the parties agree,
Ms. Karua,
Yeah.
One of us is a Seventh-day Adventist, and I'm sure there are some over there. At sunset, we cannot sit.
Well, then with that, I will not, whatever. We will try our best, but kindly be flexible. If one needs 10 minutes to finish, let's have it.
Right, we'll see. We'll see what happens. We have to make some sacrifices. We'll see whether we are able to perhaps shorten the lunch hour or that kind of thing to accommodate our council who may require 10 or 15 more minutes.
My Lord. My Lord, thank you for the time.
Just hold on.
Now, Senior Counsel, since you have said the army size, you have caucused amongst yourself, and if we totalize the amount of time that the court has allocated to each of you, it is actually something. Are you in a position now to choose amongst yourself who is going to lead? Because your issues must be cross-cutting. Who is going to lead, to take the most time to make a representation, cutting across the others' submissions, and then the others can have a shorter amount of time to stress whatever point they want to stress. That will be very helpful to both sides.
I hear you, my lady, but it will be difficult at this time because the court is already in session for us to do that. We had agreed, or the councils in each case will stress the point in their case. We'll try to manage.
Okay, thank you. Mr. Chair, what's the issue?
I wish to indicate that Dr. Jack Mwimali had filed grounds of affirmation, and will be requesting the court for at least 5 more minutes to speak to that, so it's not left unheard.
We'll see what happens when we reach you. Thank you.
Thank you, my Lord.
Yeah, let's finish with it's now 9.
My Lord, if I may, this is Professor Migaya Kej. I'm not in court at present, but if I may, there have been responses to the army chief briefs that we've filed, and we'd appreciate 5 or 10 minutes to respond to them.
Sorry, I didn't hear. We didn't hear what you say.
I am saying that there have been responses to the briefs that we filed.
Yes.
And we are requesting for some time, 5 or 10 minutes, to be able to respond to them.
No, as Amisha, we just required you to file your Amisha brief, and that is the rule as set by the Supreme Court. So we'll consider the brief that you filed. Thank you.
Much obliged.
The Honorable Mr. President, I see our time is actually set at 15 minutes, and we had requested for 20 minutes.
You have. Yeah, I know there was a request made for 20 minutes, but just proceed. We will see whether you require any more time or not. To introduce yourself for the record purposes, let's proceed. It's now 9:15.
My name is Christian Andole. The Honorable Mr. President of the Court of Appeal, my Lord Justice, my ladies and your lordships. Good morning.
Good morning.
To restate my name is Christian Andole for the 76th respondent. And today, the issue that I'll be canvassing would be the cross appeal on particularly one issue, whether the president should refund the monies used in the unconstitutional constitutional amendment process. My lords and my ladies, Chinua Achebe in his book, Things Fall Apart, says like this, that a man who calls his kinsmen for a feast does not do so to save them from starving. They all have food in their homes. When we gather together in the moonlit village ground, it is not because of the moon. Everyone can see it in his compound. We come together because it is good for kinsmen to do so. My lords, I invite you to allow me to read the provisions of the Constitution in the Kiswahili language, not because the learned bench cannot comprehend English, but because it is good for the grave digger in Langata. It is good for the shoe shiner in community, and it is good for the pregnant Wanjiku in Pumwani. It is also good for the cattle rustler in Baragoi, and it's very good for the beach boy in Watamu. These are the people, these are the wananchi. Not a person bearing the titles Honorable or His Excellency. And my Lord, a special invitation to this court is this. There has been conflicting submissions on who the promoter of the bill is. On one hand, the Attorney General, in his submissions at paragraph 69, says that the initiative is the BBI initiative, a voluntary alliance of political parties. That is the description. But they come before here, and there have been conflicting narrations of who is the promoter or who is the initiator. To that extent, the exact finding that I'm asking this court to make is this: whether the appellants have approached this court with clean hands to warrant upsetting the decision of the High Court. That is the question. Should you find that the conflicting decisions, submissions they've made, then they do not warrant the overturning of the decision of the High Court. My Lord, this shift reminds me still of the words of Chinua Achebe in his book Things Fall Apart, when he narrates about one character called Okonkwo. And Okonkwo writes like this and says like this: when I hold her hand, she says, don't touch. When I hold her foot, she says, don't touch. But when I hold her waist beads, she pretends not to know. The question is, my lords, that when you hold the waist beads of the appellants and ask them, who is the initiator of this proposed bill, they pretend not to know. That is the finding, my Lord, that I want you to make. For my Lord, the question is that where the court holds, the question is, my Lord, that the principle of constitutionalism would behoove this court to start like this, that expressio unius est exclusio alterius. To what extent am I saying this, my Lord? I make reference to our document, a bundle of authorities. The Supreme Court of Rhode Island, in the Constitutional Convention of 1883, found at page 887 of volume 2, stated this to that principle: we are of the opinion that the mode provided in the Constitution for the amendment thereof is the only mode in which it can be constitutionally amended. The ordinary rule is that where power is given to do a thing in a particular way, there the affirmative words marking out the particular way prohibit all other ways by implication, so that the particular way is the only way in which this power can be legally executed. My lords and my ladies, on to my first point, whether this court should order His Excellency President Uhuru Muigai Kenyatta to refund the public monies used in the unconstitutional constitutional process. My lords, on this is a novel issue for the following reasons. No court in Kenya has made a determination on Article 226(5) of the Constitution. In the whole of Africa, South Africa in 2018 is the only democratic country that ordered His Excellency, President Jacob Zuma, to refund approximately 1 billion shillings used in construction of his house. That was the taxpayers' money. And my lords, the history of the erstwhile Constitution of Kenya, with its 6 provisions on public finance, never provided for a provision akin to Article 226(5). And for that reasons, my lord and my ladies, the High Court's findings and declarations at paragraphs 784 to 785 of their judgment, respectively, was sufficient for an order to make good the loss of public funds. No evidence was needed for that order to be made. No evidence. It is strict liability. No evidence was needed. And if any evidence was needed, it was the evidence in the special knowledge of the appellants. Section 112. He who pays the piper plays the tune. My lords and my ladies, in buttressing this point and these findings and declarations, we rely further on grounds 2, 4, 5, 8, and 9 of the 76th respondents' notice of grounds for affirming the judgment of the High Court, dated 4th June 2021. Additional declarations, we further rely on the 76 respondents' affidavit dated 27th June 2021 at paragraphs 7F, 7E, 8, 10, 18, 20, which affidavit has not been controverted by any appellants. My lords, I also invite you to look at the doctrine of public trust that we have talked about in our submissions. The doctrine is anchored in Article 73(1) and Article 1. Article 1 of the Constitution talks and says like this: mamlaka yote makuu ni ya wananchi wa Kenya na wanaweza kutekeleza tu kulingana na katiba hii. Mamlaka ya wananchi katika katiba hii yamepewa idara zifuatazo za serikali. My lords, there is a clear delimitation of who serikali is and who mwananchi is. My lords, I also invite you to look at the erroneous application of Article 35 of the Constitution, together with unreasonable and reliance of the affidavit of the Auditor General at paragraphs 47 and 48 of our submissions, pages 47 to 48 of our submissions. And therefore, in conclusion, my lords and my ladies, with such demonstrable disingenuity, should the court fold its hands under the doctrines enunciated here of political rightness, mootness, political questions, I am afraid that the liberties of Kenyans and inalienable rights of the ordinary mwananchi would be suspended by a thread so slender than the hair strand that held the sword of the imperial King Dionysius over the head of Damocles. Thank you.
Counsel, do your best to stick to the time.
My Lord, I will request for 5 more minutes. And by introduction, my name is
You will have to stick to the time, Counsel. We really are very, very pressed for time. I wish you could start.
I'll try, my Lord. My Lord, my name is Topuale Cinco for the purpose of the record. Topuale Cinco. And just before, my Lord, I proceed with my submission, I just want to make a rebuttal on what Senior Counsel Kamau Karori said regarding the interplay of Article 38 vis-a-vis Article 257. My
My Lord, the argument by the appellants is that the president is entitled to initiate a referendum on the guise that under Article 38, which provides for political rights, the president has a right to champion the cause. And I think Justice Kiage followed that. What really happens when the parliament is robbed? My Lord, my submission is that there are enough safeguards that provides the president with avenue for lawmaking. And just to cite maybe one, under Article 261, my Lord, the president can actually have the parliament dissolved if it's not performing its function. And under Article 1.4, the people can actually, my Lord, recall their representative where they are not providing or rather carrying out their mandate. And therefore, that is not a justification to abrogate the president the power to amend laws under Article 257. My Lord, the basis also for Article 257, which gives the ordinary mwananchi the right to amend the Constitution, comes from Article 1. The reading of Article 1, my Lord, and this is actually factored also through the history of the Constitutional Review Commission and the final report. Under Article 61, the Attorney General, my Lords, have considered to the fact that the question of amendment has never been contentious in all history making of in the constitutional history making of Kenya. Therefore, the people of Kenya had a very clear mind that they intend to undo that power that enabled the rock executive parliament to mutilate the Constitution. There was therefore no hard time, my Lord, to try to balance rigidity and flexibility to amend the Constitution. And that it's my submission that the powers that the legislature, the executive, my Lords, enjoy is derived from the Constitution. And when you consider like chapter 18, page 18, sorry, of the Njoya case, Justice Ringera talks about the constituent power being primordial, that over and above the constituent power, my Lord, being derived, it is also original. That has to, it's two-pronged, my Lord, that the people are bound by the Constitution, but also the constituent power is original. And that actually takes us to a definition that in some instances that the people might not be bound by the Constitution. Any interpretation, my Lord, therefore, that says that the president is not entitled to initiate amendment of the Constitution through popular initiative, my Lord, I think will be the correct interpretation in that the people are the sovereign. They are the one who donated and constituted the legislature, the executive, and the executive can only act, my Lord, within the limit of the power that the people have donated. If the president, my Lord, therefore wants to amend the Constitution, and if it's indeed in the interest of the monarchy, the president, my Lord, can actually resign and do that in his private capacity as a citizen. And I'll direct you, my Lord.
Mr. Siko, the point was well made. Please move on to the other one. You have 2 minutes precisely.
And my Lord, I'll just direct you to a decision by Justice Nambuye between the Ethics and Anti-Corruption Commission versus County Government of Meru, where it was held that in the regime of the Bill of Rights,
which decision?
Ethics and Anti-Corruption Commission, my Lord, okay, versus Think County Government of Meru 2018.
All right.
Justice Nambuye and retired Justice Philip Waki presided over that, and it introduced a dichotomy where you view the state, my Lord, as a duty bearer and not the right holder. Therefore, the argument, therefore, that you can actually limit the right of the president to express his political rights for the interest of the local mwananchi, my Lord, actually survives. My Lord, as I conclude, I just want to point out what Dr. Viankolu left in the interest of time on the issue of political question doctrine. And our submission is that in as long as it is the interpretation of this court that the popular initiative is an individual right, then the political question doctrine should not arise. I will direct you, my Lord, to abundance of authority, the case of Arvas Miller, concluded by the Supreme Court of the UK, and also the case of Becker vs. Carr. Justice Brennan, my Lord, in that decision brings out a distinction that whenever power is clearly delineated between each arm of the government, such that when we're arguing about the executive, there's a clear line that their mandate is to do with things to do foreign relations, defense. The argument, therefore, that one has abrogated the power of the other, my Lord, should not arise. And also, we provided an article by Professor Louis Henking, arguing that the political question doctrine is actually applicable in America and is an disingenuous legal mechanic to shirk off judicial responsibility. The Superior Court, my Lord, has unlimited and original jurisdiction under Articles 165 to interpret, my Lord, the Constitution, to promote in the interest of the local Mwananchi, and that power is rightly delegated by the people under Article 1.
Thank you, Mr. Siko. Thank you very much.
Thank you, my Lord.
Thank you. Senior Counsel Karua, are you here? Sorry, Hamino, please. And can you take your 30 minutes right now?
With the court's permission, there is a young lady counsel, Caroline Kituko, and
the one who was to appear online, virtually?
She's here now, and she's requesting to be heard first. Her condition does give her to request the court to be heard first. Before. Yeah, she thinks too much sitting may affect her condition.
I see.
I'll request.
Dr. Amino, did you hear what Senior Counsel Karua said about Ms. Kituku, that her condition cannot allow her to sit down for long? She would like to make a short presentation. Before you do.
I didn't hear my Lord, I will have to watch.
All right.
Thank you.
Unless you want to do it seated. Do you want to sit down?
No, my Lord, I'm fine standing.
You're fine standing? Okay. Please introduce yourself for record purposes. And you need, I think 10 minutes would do.
No, my Lord, I represent a main party, the respondent, Muhuri, Muslims for Human Rights, who was the main petitioner in petition E2 of 2021 in the High Court. So we'll be seeking to have 45 minutes.
We were calling you yesterday. We couldn't. You could not connect virtually.
My apologies for that.
We will give you a maximum of 30 minutes. We know you are that was a main petitioner. So go ahead right now.
Thank you, my Lord. So the President of the Court and the Honorable Justices, my name is Caroline Kituku. I appear together with Mr. Muhuyu Moniki from Muhuri, the 26th respondent in the IBC appeal. We oppose the appeal, and we have filed grounds of affirmation dated the 23rd of June 2021 that we're seeking the court to affirm the High Court judgment. We have also filed the submissions dated the 23rd of June 2021. My Lord, Muhuri's case seeks to challenge the actions of the IBC to process the BBI bill in violation of the Constitution. Muhuri submits that the actions of the IBC to receive the draft amendment bill, that is the BBI bill, together with the supporting signatures, and to proceed to verify that the initiative was indeed supported by 1 million registered voters and certify the bill and forward the same to the county assembly, the IBC acted in violation of the Constitution, and in particular, Sections 10, Section 94, Section 82(2), Section 249, as well as Article 257, 4, and 5. We say so because at the time the BBI Amendment Bill was received by the IBC could not properly, lawfully, and satisfactorily discharge its mandate under Article 257(4) of the Constitution because it lacked the sufficient legal and regulatory framework to process the draft amendment bill. Therefore, it could not proceed to verify that the bill was indeed supported by 1 million registered voters and certify it as such and forward to the county assemblies. To that extent, therefore, I shall address the court on 3 aspects. The first question is whether or not IBC required a legal framework to guide it undertake its mandate under Article 257, 4, and 5. The second question would be whether or not such a regulatory framework existed as at the date the IBC received the BBI bill. And finally, the question of whether or not the procedures that the IBC used were indeed lawful, to the extent that they could help and guide IBC in the verification and the certification process. Now to the first question, whether or not the IBC required a legal and regulatory framework. It is a summation that the IBC required a framework to guide it undertake its mandate under Article 254. The High Court agreed with that summation and found that at the time that the IBC received the BBI Amendment Bill, it required to have a form of a legal and regulatory framework to guide its work. You will find that finding at paragraph 752 of the High Court judgment. We therefore urge the court to affirm that finding for the following reasons. Number 1, Article 82(1) of the Constitution mandates Parliament to enact a legislation to provide for the conduct of referenda as well as elections in this country. It is therefore the obligation of Parliament to ensure that there is a law in existence that would seek to guide the processes that are associated with the referenda in this country. My ladies, there are many authorities from this court and as well as from the Supreme Court that hold that an election is not a one-day event, it's a process. Applying the same reasoning in this matter, we would urge this court to find as much that a referenda is not a one-day event, it's equally a process that starts right at the time a promoter comes up with the idea to amend the Constitution, to the point of collecting signatures, to the point of taking them to IBC, to the point the IBC verifies them, certifies them, takes them to the county assemblies, takes them to Parliament, and eventually to the referendum and the counting and the declaration of the referendum result. It cannot therefore be that the law that IBC seeks to rely on, that only provides on the conduct of the referendum, is the sufficient law. There is no law at all that provides for the verification and certification processes under Article 257(4) of the Constitution. Such a law has not been provided in this court because it does not exist and it is not there. The law that this court was referred to exists in section 49 to 55 of the Elections Act. My lord, my ladies, a careful reading of that law will show that it does not in any of its provisions provide for the procedures on the collection and verification of signatures, on the procedures for certification, and on the procedures that are supposed to be undertaken by IBC insofar as its mandate and Article 257(4) and 5 are concerned. My lord, conscious of all the processes that are required to give effect to the referendum, the Constitution has therefore mandated Parliament to enact the law to regulate those processes. And the reason for this is not difficult to find. It is because each of the processes that are required in the context of the referendum, and in particular Article 257(4), right from the point of collecting signatures to the declaration of the referendum results, if at all, are important, they are fundamental in a democratic society. It cannot therefore be true that Article 257(4) and 5 is self-executing, as this court was told by the IBC. How does it execute itself? Well, it does not have any procedures or any provisions on how signatures are supposed to be collected, verified, and certified. My lord, having said so, the next thing we need to consider is the mandate that the promoters of a popular initiative have under Article 257(4). The obligation is to deliver the draft bill and the supporting signatures to the IBC in order for the IBC to be able to verify indeed that the draft bill and the proposals therein are supported by 1 million registered voters. The question therefore is, what is the role of the IBC upon receiving the draft bill and the supporting signatures? The High Court, at paragraph 734 of its judgment to 741, set out in detail what the IBC is required to do in order to give effect to the provisions of Article 257(4) and 5. The first thing the court said, which we seek to have this court affirm, is that the IBC must verify that the bill to amend the Constitution through a popular initiative is indeed supported by at least 1 million registered voters. My lord, my ladies, it is also mentioned that IBC indeed understood its mandate to that extent very well. To that extent, I therefore refer the court to the record at page 3202 to page 3208.
Yes, continue.
Page 3202 to 3208. The record clearly indicates and provides evidence from the IBC itself. IBC in those pages especially starting at page 32.0, came up with what it is calling the budget for signature verification. At page 32.03, when it came up with a budget, it funded it to the National Treasury. At page 32.03 of the record, we will find a document in form of a letter dated the 16th of December 2020 from the Cabinet Secretary, National Treasury and Planning. Paragraph 2 of that document clearly authorizes IBC to go ahead and spend some 93 million thereabout in the process and in order to undertake verification of signatures following the draft bill and the receipt of those signatures by the promoters of the draft bill, being the Building Bridges Initiative. All the way to paragraph 30 of the record, you will find a document from the IBC that seeks to make announcement for vacant positions for persons who are going to undertake the verification of signatures work at the IBC. It called members of the public to apply for that job, and it listed the criteria that it was seeking from those people. At page 32.07, you will find a tweet from the Twitter handle from the IBC that informs members of the public that indeed IBC has started its verification processes of the signatures that it received in support of the BBI bill. Finally, at page 33.08, you will find a document that is known as the Administrative Procedures for the verification of signatures in support of a constitutional amendment referendum. All along, and all those documents demonstrate one thing, that what the IBC sought to do was to verify the signatures that were submitted to it in support of the draft amendment bill. To that extent, therefore, we submit that for IBC to have been able to do that particular mandate constitutionally, it required some form of a regulatory framework to enable it to undertake that important constitutional obligation. My Lord, my ladies, Mr. Ngumbo informed and submitted in this court that Article 257.4 has 3 aspects. He referred to the aspect of the first one being an initiative, the second being verification, and the third being supported by 1 million registered voters. My Lord, my lady, we submit that he conveniently and properly sought to misguide the court by omitting the 4th aspect, which is a draft bill that is supported, the draft bill and supporting signatures. There cannot be an initiative, it cannot be an initiative without a draft bill and its supporting signatures. A careful reading, or a plain reading actually, of Article 257.4 indicates that a promoter of a popular initiative cannot deliver the draft bill to IBC without the supporting signatures. So what is then the purpose of the supporting signatures? Or rather, put differently, why did the Constitution deem it important that for a promoter who intends to amend the Constitution must collect supporting signatures and have them delivered to IBC and not DCI? What then was the intention behind that provision in the Constitution? Mr. Ngumbo made this court believe that the supporting signatures are not useful at all. in our view, it could not have been the intention of the drafters of the Constitution to have the signature requirement for cosmetic purposes. No. Had the Constitution envisaged that the IBC should use those other unique identifiers, as Mr. Ngumbo told this court, then nothing, my lords and my ladies, would have been easier than the Constitution to say so. To that extent, therefore, I seek to rely on paragraph 12J of the affidavit of Mr. Michael Goa, at paragraph 12J of his affidavit in opposing the petition before the High Court and in support of the IBC case, stated that a signature is just one of the unique identifiers that IBC can use to verify whether or not a supporter of the initiative is a registered voter. He states that IBC has other identifiers which are unique to IBC, such as a surname, for example, an ID number, the sex of the registered voter, the date of birth, and so on. Then the question is, why didn't the Constitution use any of these unique identifiers in order to identify, indeed, that the registered voter is the one who is supporting the initiative? I submit that there was a reason why the Constitution uses signatures, and that reason cannot be overlooked by this court or by the IBC. Mr. Ngumbo further informed this court that by requiring IBC to verify signatures, we are basically requesting the IBC to undertake forensic analysis and work that is a preserve of the DCI. My lord, my ladies, that summation is incorrect. We say so because Michael Goa's affidavit as well, at page 3287, that is paragraph 12K, paragraph 12K, it states that in respect of every registered voter, IBC has a record of all Form A's which contain the signature or thumbprint of a voter, the constituency of that voter, the county that voter comes from, the ward that voters come from, and so on. Therefore, it cannot be that IBC, when it says that it keeps Form A, which has all these details about a voter, including the signature of the thumbprint, can now purport to say that it does not have a means to verify the signatures, whereas it does hold those signatures. The question then is, do we need DCI to undertake a forensic analysis? We submit no. An analogy would be made. Every bank, if you have an account in any bank in this country, the bank has your signature. How does the bank verify that signature without having to undertake a forensic analysis from the DCI, as Mr. Ngumbo makes us want to believe? In addition to that, at page 3217, at page 3217 of the record, you will find a form produced by IBC in opposing Muhuri's petition. The form is titled Form for Collection of Supporters' Details and Signatures. the IBC envisaged and actually did create a format through which a promoter of a popular initiative would use to go out there and collect signatures. What are these signatures for that it intended, and what are they to do with them if they did not have an obligation to verify them upon receiving the signatures? Further, my Lord, I refer you to paragraph 12(o) of the affidavit of Michael Goa, where it states that the responsibility of the IBC after verifying, it states so. It's not our evidence, it is IBC's evidence. The responsibility of the IBC after verifying signatures is to send the verified signatures to the promoters and public for confirmation that indeed they gave their signatures in support. So the question at this point is, did IBC do so? Did IBC at any point verify the signatures? Did it send them back to the public for verification? To answer that question, I refer the court to page 3340. Page 3340 of the record, where you will find a document called Notice of Interim Verified List of BBI Supporters. At paragraph 2 of that notice, the IBC states it undertook data cleaning exercise by removing incomplete records. That is, I'm quoting verbatim, that is, missing signatures, ID numbers and names, duplicates, and those not in the registered voters. What IBC then tells us, the members of the public, it did was to do a cleaning exercise. It undertook a data cleaning exercise as opposed to verifying the signatures. It never came out to provide a list that had proper supporters and their signatures that it had verified. What it did, it used again the unique identifiers in the list that it sought to upload in its website.
Council, you have 5 minutes to go.
Further on that issue, we submit that until now, the position of the IBC on this process is not known. I say so because Mr. Ngumbo told this court that IBC could not verify the signatures, but on further cross-examination or rather questioning by the member of the bench, Justice Honorable Kiage, he stated that IBC verified. The question therefore is, what did IBC do? It is not known, it is unknown, and that's why its actions are not accountable to anyone or any person. Mr. Ngumo further informed this court that IBC did not have a database of signatures. Indeed, that evidence is also on record, and I refer you to page 3197 of the record, where you will find a letter by the IBC to Muhuri confirming that indeed it did not have a database of signatures. But all this contradicts IBC position, and it does so because it states, first of all, it has a Form A in its custody. The Form A apparently has the signatures of every registered voter. It further goes and informs my client that it does not have a database. So the position until now of the IBC cannot be ascertained, not by this court, not by any other independent person, because whatever it did to do was not accountable and was not in any way verifiable. On that issue again, Mr. Ngumbo gave an analogy to this court. He told this court a few days ago, Kenyans were able to complain to the registrar of political parties that they had been registered without their consent as members of various political parties in this country. Why were Kenyans able to make that public outcry? They were able to do so because the register of political parties maintains a system that is verifiable, simple, transparent, and credible. All that a Kenyan citizen needed to do was to go to e-citizen platform, input their ID number, and have the details of whether or not they're registered as a member of a political party. Can the same process be said of the IBC and in the manner in which it is sought to conduct its mandate under Article 257(4)? We answer no. IBC did not have a simple, accessible, and verifiable process that it could have used in relation to satisfy that indeed the initiative was supported by more than 1 million registered voters. Finally, before I log off, I would like to refer this court to the administrative procedures that apparently the IBC said it used. The IBC, in its own administrative procedures, and those procedures you'll find them at page 3208 to 3216 of the record, it states step by step what it is sought to do and how it is sought to do it. From paragraph J, it states step by step on verification of signatures, getting budgetary allocation, going to verify both the print and the soft copy of the signatures. It states clearly what it was supposed to do, but did it follow its own procedures? It did not. What it did was to do a data cleaning exercise. We therefore urge this court to affirm the High Court findings that the IBC, in the manner in which it carried out its mandate under Article 257(4), violated the Constitution as well as its own procedures that it had developed to assist the court.
Thank you very much, Counsel.
Thank you, my lord, and I will seek, because I could not cover everything that I intended to refer the court to submissions.
Yes,
and
yes, thank you very much.
I will do so. Thank you very much.
Thank you. Senior Hanzo Amino.
Permit me to say good morning, my lord.
Good morning, Dr. Amino.
Yeah. My lord, may I say I'm very proud and very happy to have the privilege of appearing before your lordships. My lords, before I go on, Justice Musinga, President of the Court of Appeal, we thank you very much for the efforts you have taken to put us in very civilized surroundings. I know what it means to have had to put up such a structure at a very short notice. We remain most grateful to you.
Thank you.
My Lord, may I take this opportunity to congratulate my Lady Justice Okwengu. Lady Justice Okwengu, may I say to you, we remain proud of you. I have had a privilege of appearing before you since the days you are magistrate, a high court judge, and court of appeal. Some of us who have known you for a long time will remain most proud of you, and I convey to you my sincere congratulations and wish you very well. My Lord Justice Tuyot, I equally congratulate you for having been elevated to the Court of Appeal. It was always a pleasure to appear before you when you are High Court Judge. I always looked forward to the time I'm going to appear before you, and I was happy with the points you used to raise, questions you used to ask me, to interrogate me, and I look forward to continuing to appear before you. I wish you very well on the bench. My Lords, may I say one or two things? The President of the Republic of Kenya, the Honorable Mr. Justice, the Honorable Uhuru Kenyatta, has filed an application, and I'm inviting you very respectfully, my Lords, that you do not take note of the application that he has made before you at all. My Lord, while he was at Kisumu, he made certain remarks about judges. My Lord, he has failed to get two judges who are involved in this case in the High Court to be sworn in as Court of Appeal judges. That is Justice Udunga and his colleague who have not been sworn in at all. My Lords, when you come to the court, you must come with clean hands. The President has not come to this court with clean hands at all. And I'm humbly urging you that you borrow a leaf from South Africa. You borrow a leaf from India and Pakistan and say to him, no, we shall not hear you. The orders that were made by the Court of Appeal must stand. He has deliberately refused to swear in judges. My Lord, it's my humble submission that when you are coming before a court, you cannot despise a judge and at the same time you appear before a judge and you expect that judge to give you orders at all. May I say, my Lords, when you appear before your Lordships, we come with tremendous humility. We speak politely to you. We praise you. That praising, that humility, and that courtesy that we extend to the court is not for you personally. It's for the good of the entire country of Kenya, to get our people to continue to have confidence in the judiciary and in the administration of justice in our country. And when you have a president who is not obeying court orders, when you have a president who is demeaning judges before the public, this court must stand firm and say to him, no, we shall not hear you. We shall not give you orders at all. Again, I respectfully urge you, you borrow a leaf from India. You borrow a leaf from Pakistan. You borrow a leaf from South Africa. declined respectfully and said to him, "We shall not hear you, and whatever complaints you have, raise those complaints before another court, but not this court at all." My lords, the 2010 Constitution, perhaps before I go on with that, I have made a list, my lords, which I may give me those. I have made a list of some authorities or some books I have, which I know that your lordships may not be having them. And I would be prepared to list them to the court through the registrar if that would be. My lords, I have included them in a list of authorities here. If you may permit me to hand them to you.
But be mindful about your time, eh?
No, I know, my lord, as usual, you'll be kind to me.
No, not today, Dr. Haminwa, Senior Counsel. You have precisely 23 minutes now remaining.
Yes. My lords, the books I have are in constitutional amendments by Yaniv Rosnai, Constitutional and Political Theory by Ernest Wolfgang, a constitutional judge of Germany, Making Constitutions in Deeply Divided Society by Hannah Lerner, Constitutional Amendments by Richard Albert, and an amendable Constitution by Richard Albert Batil Emran, the Foundations and Constitutions of Constitutional Amendment. There is one book I have not brought to the court, but I'll make it available if the registrar asks me. It's called The Theory of Imperfections in Constitutional Making and Constitutional Amendments.
Yes.
My lords, the Constitution of Kenya 2010 was a response to two things: to the rotten history of this country,
yes,
and to development of international jurisprudence or global jurisprudence. My lords, those of you who are young may not know that this country has a rotten history. This is set out in two books. One is Kenya, A History Since Independence by Professor Charles Hornsby, Professor of International History, I think, at the University in Australia. The other one is Kenya Between Hope and Despair by Daniel Branch. My lords, Condoleezza Rice was now, I believe, a professor at Stanford University. When she was security advisor to President George Bush, in her new book that has come out, Democracy, Condoleezza Rice, at page 127, there is only one sentence, my lords, which I would like to read to you. At page 217. On Inauguration Day, that's our President Mike Kibaki, told Kenyans that he was inheriting a country badly ravaged by years of misrule and ineptitude. That was a correct statement. There were assassinations in the country. Pinto, J.M. Kariuki, Tom Mboya, William Ouko, and etc. Many assassinations. People died in suspicious circumstances. Some left the country in exile. People like Ngugi wa Thiong'o, Mazrui, they left the country. There was rampant corruption in the country. My lords, the Constitution, the 20th Constitution, was intended to take care of this. The judiciary was not spared. There was no security for judges at all. Some judges, some judicial officers died under suspicious circumstances. These were things that the new Constitution was supposed to take care of. And my lords, if you read the Constitution very carefully, the way I do, you will find that it does take care of certain things. Certain officers are entrenched. The office of the DPP, the office of the Inspector General, Constitution, to send a message to Kenyans and the whole world, never again shall we go through this kind of life. Never again shall we go through this. The way the Japanese Constitution has a provisions to the effect that never again shall we have war. The way the Cuban Constitution has a provision, never again shall we go to capitalism. We say to the whole world that never again shall Kenya have this kind of life. And my lord, this is repeated in the Constitution. If I may refer you to Article 255 of our Constitution, dealing with amendments, 255. My lords, if you read 255, 256, and I believe, yes, 255, 256, and 257, it emerges very clearly, my lords, that this Constitution is unamendable. This Constitution is unamendable. And it is not surprising, my lords, that in one of the books, sorry, my lords, we are not as organized as we should be when you are appearing before the Court of Appeal. My lords, if you go through this book I refer to, unconstitutional constitutional amendments, unconstitutional and constitutional amendments, my lords, if you look at page, this is page 236, my lords. Page 236 to page 274. 236 to page 274. Yanim Rosnai, in his thesis for London School of Economics, he has a heading, Explicit Substantive Unamendability of World Constitutions. Explicit Substantive Unamendability of World Constitutions. My lords, he has set out all the countries that have unamendable war constitutions. And Kenya is one of them. Kenya is one of them. My lords, Kenya is one of them, and I'll read to you at page 258, he has set out very clearly that Kenya is one of the countries that has an amendable constitution. And he quotes articles 255.
Would you kindly speak to the microphone?
Oh, sorry, my lord. Yeah. Paragraph 255 to article 257. Paragraph 255, I have article 255 to article 257 as unamendable. And the reason he gives different procedures for different provisions, different procedures for different provisions, different provisions for different procedures. And indeed, my lords, when you will look at these articles, when you are writing the judgment, articles 255, 256, 257, you will find they have different procedures for amendments. When you apply them, it's difficult, impossible to carry out effective application. It is cumbersome. It is onerous. You cannot actually carry out into practical terms these provisions at all. My lords, it's my humble submission that one contribution that this court should make to the able judgment that was delivered by our 5 judges, that is Justice Ngugi, Justice Odunga, Justice Teresa Matheka, Justice Mwita, and Justice Jairus Nga, is for you to strengthen that judgment by making a firm finding or a firm order that the Constitution we have now, the 20 Constitution, is unamendable. My lords, that is not wrong. You will be protecting democratic values of the country. To have at the moment a constitution that is unamendable, you are protecting democratic values of the country. There are some people in this country who would like to take us to the old days. We must say to them, no, you will not. We have an amendable constitution. And an amendable constitution, there is nothing wrong with that because it is protecting democratic values. My lords, constitutions of the world, whole world, the global kind of development of jurisprudence is towards having constitutions that protect democratic values. And this has been summed up in these 2 books, my lords. My lords, I refer to the books called Constitutions of the World. I believe you must be having a set of 4 volumes. They are produced by the Indian jurist M.V. Paile, Constitution of the World. And you find that these constitutions have communality, separation of powers, the role of the judiciary, the role of the executive, the role of parliament, and they have entrenched provisions in all these constitutions. My lord, there was an attack on India about basic structures. May I deal with that? My lord, India has been on the forefront in jurisprudence or international jurisprudence. My Lord, you may remember Bangalore principles which were brought about by Chief Justice Bhagwati. India is a member of the Commonwealth. We are members of the Commonwealth. What happens in India, we cannot afford to ignore it. We apply Indian authorities from time to time in our courts, and we cannot say something trying to despise India or trying to show that India is different from us. My Lord, with complete respect to my learned friends who said that is completely nonsensical. We ourselves have a lot in common in India. India is, as it were, our sister country. We have a significant population of Indian origin in this country who continue to make a significant contribution to the development of this country. So what happens in India is of considerable importance to us as a country. Now, my lords, if you take the basic doctrine, you will find that it has spread to many countries. It has spread in Asia. It has spread in Africa. It has spread to Caribbean. It is a part of the global development of global jurisprudence development. It is what you can call part of international jurisprudence. Perhaps I should also add, my lords, that we had a very good meeting also in India of lawyers, including judges, and this book was produced of challenges to the legal profession and investment in developing countries. Again, this was in India. Now, the basic doctrine, my lords, can be taken to be part of the definition of the word amendment, which you will find in the New Oxford English Dictionary. Yeah. And my lords, I've just been advised by Valentine Khaminwa that the word amendment has to be, is in singular, is not in plural at all. My lords, I have filed submissions, written submissions. I hope you have got this book, one that is dated this one. Which one is this one? Yes, we filed submissions, my lords, on 23rd for Kenya Human Rights Commission. They should be there. We filed submissions, Kituo cha Sheria, on 24th June. They should be there. My lords, may I say this?
In 5 minutes, please.
Yeah, I'll take a short time, my lord. I don't intend to take much more time than that. May I say this, my lords? My learned friends who appeared for the appellant, I listened to them very carefully. And I thought that some of them, whom I happen to know very well, who are great friends of mine, very close to me, and I talk to them from time to time, I got the impression that some of the things that they were submitting to your lordships, they are not things that they really stand for.
They are not what?
Things that they stand for. Poor. Most of them are job seekers.
The microphone for record.
Yeah. Most of them are job seekers. They stand absolutely for nothing. And you can see even when they are campaigning, They do not tell anybody what they would do when they come into power. One gets the impression that all that they're doing is looking for a political office. The nearest politician or politician surplus for the years I've been in Kenya, the nearest we have is the late Professor Wangari Maathai. I served him as his advocate. I appeared for him in courts. This was a great lady. She was selfless in many respects. And the other two I would say, or what the other one I would mention, my Lord, is who was selfless, is Kenneth Matiba. My Lord, the first group of politicians who brought us Uhuru in this country was selfless. But after that, the politicians who come into power are tribalists. Most of them are tribalists. They are advancing tribal agenda. My Lord, what they stand for is really to see that they come into power. And the problems they have are their own personal problems. We have to appreciate that the law has got limits, its own limits. Professor Allott tells us so. The Constitution has got limits. That's what we learn from constitutional jurisprudence. And whatever problems we have in this country have absolutely nothing to do with the Constitution. They have nothing to do with the law. They have something to do with ourselves, and particularly the political class. When it comes to violence, they are the ones who are actually, one can suspect, they are really the ones who are fueling this violence. This is set out in the book of
You have a few seconds, Dr. Amino, please.
Yeah, my Lord, may I draw your attention to Interrogating Marginalized Governance by editor Professor George Garner from our university. That is the book I had in mind that I would like to draw your attention to. My Lord, may I say thank you very much.
Thank you.
I urge you very respectfully, you throw out the appeal. It has no merit. Absolutely none. The submissions that were made before you were pedestrian submissions. Were not in good faith. Instead, my Lord, I'm inviting you respectfully, you uphold the judgment of the High Court and you improve on it.
Thank you. Thank you.
Thank you very much.
Thank you, Senior Counsel. Can we have Senior Counsel Martha Karu? Yes.
May it please the court, I'm Martha Karua, appearing with Muthoni Nyuguto for 3 amici, that is Dr. Ojwang, Duncan Ojwang, Dr. Linda Musumba, and Dr. John Osogo Ambani. I propose to use 20 minutes and seek extension if necessary, and leave 10 minutes to my learned junior, Muthoni Nyuguto. The documents we have filed are written submissions dated the 22nd of June this year , with 2 annexures. Digest of Authorities, dated the 22nd of June this year. Bundle of Authorities, dated 22nd June this year. All three bound in green. 4. Proposed Amishi Brief adopted by High Court, which appears on page 1072 of the AG's record, volume 3. Finally, written submissions dated 9th March this year, with 2 annexures appearing at page 1016 in volume 3 of the AG's record. Those are our documents. If it may please the court, constitutions exist to limit the exercise of authority, and this does not appear to be understood or taken into consideration by the executive in Kenya, and indeed by many state entities and state officers. And it is clear to me that modern dictators, especially in Africa, are using the constitution or constitutional amendments as a special purpose vehicle to claw away on civil liberties and democratic gains. And we have examples all around us, even in the sub-region, where extension of presidential terms through constitutional amendments have been happening. The point I'm making, my lords, is that while pretending to observe the Constitution, the political elite will use amendments, unconstitutional constitutional amendments, to ensure that they extend their stay in power and concentrate power in their hands. It is our humble submission that this is a consideration that this court ought to put in mind when evaluating this case. The Constitution of Kenya 2010 recognized the danger of this behavior by the political elite. And if you look at the history, which is the CKRC report attached to the Attorney General's record and has been cited page 74 to 76, you will see the fears Kenyans had in the making of the Constitution, that the political elite would mess with the 2010 Constitution much more the way they had messed with the Independence Constitution through hyper amendments. This history is important in evaluating what is happening. When my learned friend, Mr. Senior Counsel Orengo and Senior Counsel Amolo were here, they were happy to state they were part of the constitutional review. I would like to say that I have lived that history too. Throughout the formal process, the more than 20 years of search for the Constitution, and during the tail end, as a member of the Parliamentary Select Committee with my learned, my friend Senior Counsel Orengo, and part of that time as the Minister of Justice. And I want to refer the court to the Constitution of Kenya Review Act 2008, revised in 2009, and in particular to Section 23, which spells out the function of the committee, to Section 31, before 31 to Section 29, which says what materials the committee would use. And why I'm doing this, because the court has been told that the Constitution of Kenya 2010 is a political settlement. It's quite clear from the mandate given to the Committee of Experts in that act. What the Committee of Experts was doing was to rely on all the documents, all the views given by Kenyans, and to resolve the contentious issues, and to ensure that the review process faithfully reflected the will of Kenyans. So when we are told that it's a political settlement, far from it. It actually reflects the will of Kenyans, and yes, there were political settlements in Naivasha. And those settlements related to the system of government, to the form of devolution. I'll mainly talk of those two and say that even in resolving the political system, as part of the group in Naivasha, we did not go beyond the suggestions given to the Committee of Experts. We just picked the presidential system from among the three options: hybrid, parliamentary, presidential. So even that was not far from the wishes of the people. And I know that the political party I lead and several others had actually presented to the COE for a presidential system. So even that choice was influenced by the views of Kenyans. It was not merely the wish of politicians. And devolution, having picked the presidential system, we adopted it to our situation to be devolution in a unitary system. So what I'm saying is that this is a process reflecting the dreams and aspirations of Kenyans as stated in the preamble of the Constitution. My lords, in the 2010 Constitution, the judiciary, in Article 1 and Article 159, judicial authority must be exercised for the purposes and principles in the Constitution and shall be protected and promoted. And judicial authority must be guided by the principle that justice shall be done to all irrespective of status. This again is anchored in the Bill of Rights, Article 27, which clearly states that everyone is entitled to equal protection and equal benefit of the law. I'm emphasizing that, my lords, I know you know it, but it is important that we remind all of us that nobody should come to this court with a sense of entitlement, however mighty. Once you enter the doors of the court, you are a litigant just like any other. We are therefore asking the court to ignore all statements that have been made extraneously, some of them predicting the outcome of this case, sounding very much like a team member in a boxing match shouting to the opponent that they've already won before the match has started. We urge the court to take its time to read the submissions and the authorities cited and the proceedings of the Superior Court, and to see that the Superior Court discharged its judicial duties admirably in a well-reasoned judgment and gave declarations pursuant to its powers to interpret the Constitution. It was suggested that before by the appellants that the Superior Court or the High Court cannot give advisory, only the Supreme Court. We have no quarrel with that. The High Court did not give advisory. It made declarations as it's entitled to do. This was a suit seeking declaratory judgment, and the court pronounced itself as required and as it is entitled under the law. My lords, my ladies, I submit that we are yet to fully implement our 2010 Constitution. It's a work in progress. And Kenyans, knowing that the political class may be a hindrance, and indeed it has been, to the faithful implementation of the Constitution, not only to interpret, but under Article 165, to determine whether anything said or done under the Constitution is constitutional. That is what the High Court was asked to determine under 165, and all they did was to discharge their duties. We urge you, in reviewing the evidence, to come to the same conclusion and to find that the High Court, the judgment before you, is safeguarding the dreams and aspirations of Kenyans. And indeed, it is the duty of this court as the guardian of the Constitution, or the duty of the courts as the guardian of the Constitution, to ensure that it sets beacons, it sets limits as demanded by the Constitution of the exercise of of authority, not of judicial, but of authority by the political elite. I want to say that this court's powers are not inferior to those of the executive. All the arms of government derive their power from the people. And this court has the final word on the interpretation of the Constitution. Drawing on my learned Junior Mudhomi's analogy yesterday, we invite the court to use its sword to mark the beacons of exercise of power by the executive, and to find that the judgment of the High Court should be upheld and the appeal dismissed. Coming now to the question of the attack on the role of the amici in the High Court, which is ground number 6 of the Attorney General's appeal. We submit that the amici discharged their role of advising the court, of assisting the court, of maintaining fidelity to the law, of being impartial, and this is shown in the submissions of the amici before the High Court, which are on page 1019 of the Attorney General's record of appeal, and also the submissions by our clients before this court, which are already before you. We were cited as respondents and therefore came to court as such. But the sum total of our submissions will show fidelity to the law, impartiality, the fact that part of our submissions may coincide with the submissions of parties. That does not make the amici biased per se. The amici are talking of the law as it is and assisting the court mainly to understand the basic structure. And coming to that, my lords, my ladies, our submission is that the basic structure is inherent. It is part of the DNA of any constitution. whether it has been designed or not, as a matter of fact, every constitution has a basic structure. Ours is no different. And if you look at Article 255, you will see protected clauses, which we submit are part of the basic structure of the Kenyan Constitution 2010. We ask you to be persuaded, like the High Court was, that indeed 2010 Constitution has a basic structure and that the basic structure doctrine is applicable to Kenya. My lords,
yes.
The implementation or the realization of the dreams and aspirations of Kenyans depend on the courts as guardians of the Constitution. It is through pronouncements of the court, without fear or favor, that this country will eventually achieve the transformation envisaged by the 2010 Constitution. We invite you to rise up to your duty, and in Dr. Mudhomi's words, to utilize the sword to slay the monster. And the monster, I dare say, is the monster of impunity, of self-entitlement of the political elite. Indeed, the court must enforce the limits of power as enforced by our Constitution. My Lord, I have something I would like to put to you as an officer of this court. When public officers come before the court, don't they have a duty to be impartial and to actually give the court, to the best of their ability, the issues as they are? And to that extent, can the IEBC come to court to protest on the issue of quorum, knowing very well that they are not fully constituted, knowing that the steps to fully constitute them are under the way? Should they waste public funds, public resources, time and money to come and contest such an obvious point? Should the AG, who ought to have advised the executive and the government to replace the commissioners who resigned immediately, should they waste public resources coming to canvass this point before the court, or should they have considered and said the work is underway? Can the IEBC contest the issue that there is no referendum law, the IEBC and Parliament, yet there is a referendum law pending now before Parliament, meaning that they have already identified there is a gap and they are working to redress it? Yet we hear the Parliament and the Attorney General canvassing, not the Attorney General but IEBC, canvassing this issue before the court. Is this prudent use of resources? What is the court's role in this? Is this a case where the court should reprimand those officers, those state officers, and even ask them to bear the costs? It is happening too often, where state officers take Kenyans who question as their enemy instead of serving them equally with others. These are the questions that are before the court, and I dare say they demonstrate the impunity which permeates ranks of state officers, the executive, very much of government. We are asking the court to utilize that sword to slay the monster. Parliament delayed the appointment of those commissioners by not passing the law. Can they use their delay to come and ask the court to find otherwise? These are the questions we are asking. We urge the court to dismiss this appeal. and to affirm the judgment of the High Court. I yield to my learned junior, Muthoni Nyuguto.
President of the Court, Your Lordships and Ladyships, I am Ms. Nyuguto Muthoni, and in the brief time that I've been given, I'd like to address in brief the issue of public participation, the remit of the Constitution with regards to amendments, with regards to Article 257, and briefly touch on the basic structure doctrine. I'll begin with public participation. And public participation itself.
Counsel, sorry.
Yes.
Now, when we gave you the opportunity to address us,
yes,
it was in respect to the criticism that was made of your role.
Yes.
Not in respect to arguments.
Yes.
Either supporting or against the appeals that are before court. Because for the rest of the amici, we left that to their written arguments. So the criticism you are given the opportunity to react to was that you were impartial. Those are the directions we gave.
Your Lordship, with your guidance, some of the issues that I am highlighting were also criticized, and these were the basis that the appellants used to come to the conclusion that we were partial. So I'd just like to highlight, please.
Please do so in your 10 minutes.
Okay. As I was saying, public participation itself is the essence of democracy because it broadens the constitutional agenda. Public participation itself legitimizes the Constitution. It allows people to be committed to their Constitution through the level of public participation that was involved in their making. A key critical issue that we raised is the deprivation of human rights and citizenship, which first manifests in the lack of public participation within constitutional amendments and making processes. And it was our view, which has been attacked, that authentic and effective public participation does not occur when a proponent or a promoter of an illicit public initiative comes up with a problem, it formulates a solution to that problem, then goes ahead and invites the public to give in their input to this initiative. This public participation within this context is ineffective. It is conflicted. Why? Is because it happens too late in the process, after all the issues and all the agendas have been framed, and most of the decisions have already been arrived at. We submit that the BBI constitutional amendment process failed to reach this threshold of authentic, effective public participation. This is because our reasoning is that when it comes to constitutional amendment process, the rigor is not the same as constitutional making. You can find that within an amendment process, the proposers or the promoters have secured the bare minimum of the votes, even before bringing and tabling to the populace, to the people, what this initiative is about. This itself, as it happened with the BBI constitutional amendment process, kind of short circuits and leads to an outcome that is already predetermined. Your Ladyship, there's a real difference between going through an empty ritual of public participation. Public participation by itself should enable the people to have an effect on the outcome of that participation. This was the history, and this is what informed the Superior Court as captured in paragraph 414 to 426. This process of the BBI constitutional amendment process, from the above, therefore, is not effective participation, rather tokenism. The law enjoyer, as captured in paragraph 3 of our digest, will show that public participation ought to have been effected before the collection of signatures. This itself did not happen. And more critically, I'd like to bring to the attention of the court that in appropriate circumstances, courts have considered actions and their impact that limit public participation and requires that these actions are postponed until after elections, especially when we are gearing to an electioneering period. This is supported, of course, in the case of Consumer Federation of Kenya versus the Minister of Information and Communications, as captured in page 4 of our digest. We urge the court, in dismissing this appeal, to consider the critical constitutional moment that we are in. We seek to effect large changes that have not met the participation threshold right before an election.
Counsel,
yes.
Just a moment, please.
Yes.
You are saying we should consider critically the constitutional moment in which we are. Are you saying we are in a constitutional moment? Because that is an issue that has emerged from the record.
From the record and from our understanding is that the BBI amendment process seeks to usurp, seeks to change, seeks to replace the existing constitution. They have created an ideal, a situation that is not within the interest of the Constitution. It seeks to usurp the Constitution as it is and replace it right before an election.
Karen, please. Thank you.
And this is especially within the context that public and effective and authentic public participation has yet to be carried out. On the issue of constitutional nature and remit and power of amendment with regards to popular initiative, I will restrict my submission to these critical questions. When public officers and state officers promote a popular initiative bill or amendment, they pose a threat and they seek to dilute the content of Article 1 on our sovereignty. The exercise of our sovereignty, as under Article 1.2, is very clear. The people may either exercise their sovereignty power either directly or through their democratically elected representatives. The key word here is either directly or. So there's no overlap, there's no interchange. The people, being the sovereign, have retained the question of amending their constitution within the popular initiative to control their own course within the constitution. There is no interdependence of those roles. So when a state officer or the president promotes a popular initiative, these questions arise. Whose interest are they articulating? Whose interest will be excluded? How are the views of the participants going to be aggregated? What is the degree of public participation? Who bears the cost, and what is the benefit of that participation? And why? Why should one particular popular initiative drive benefit from the backing of the state or the public officer while others have not? The answer to this question is the very reason why the roles of rulers and governed are distinguished in Article 1. Quickly on the basic structure, the question remains. It has not been answered. What is basic structure? Basic structure is inherent. It's juridical. It is not an invention of courts. What I mean is that it can only be discovered, but it cannot be invented by courts. The Superior Court had no obligation to create basic structure. It is inherent. Just like human rights, it can only be discovered, it can only be acknowledged, it can only be realized, but it cannot be created. However, it can be ignored, it can be violated. Therefore, it can be granted by the state. It cannot be granted by judiciary, executive, or parliament.
Can it evolve or be enhanced?
It may be enhanced, however it exists, it's DNA. It is the theoretical foundation. Who is Muthoni Nyuguto? You can say she has limbs, she has legs, she's short, but it is my DNA that really identifies me. That is basic structure. And what you've not been told by the appellants is that they have admitted that the Kenyan 2010 Constitution has a basic structure. It has a core, which the AG had stated can be called or identified as basic structure. If you allow me, then how can courts discover this basic structure? It is through looking at all the collective provisions that account for the Constitution text, our history, and other non-legal considerations. Countries like ours with dark constitutional histories, as my learned senior Professor Dr. Muthoni stated, have put in judiciary to protect the basic structure of the Constitution. I see my time is up, but I pray for 5 minutes to sum it up.
No, we'll not give you 5 minutes.
President, 2 minutes only.
Two then?
Yes, please. It can be discovered, but looking at all the collective provisions that provide for constitutional making processes. Essentially, it is looking at all the provisions of social contract between the people and the state. It is all the provisions that provide or give power for the control of government and the bureaucratic administration of the state. These are in terms of 4. The first is public participation. It allows citizens to discuss, to be involved in decision making before laws and constitutions are made. It is the equality of political actors, in that the people, the citizens, are treated as political equals with their elected rulers. And this is what happens in ballots. It is within the concept of universalism, reaching a decision that is common, it's for the common good of the people. It is on citizenship, which seeks to decentralize the power of decision making to the grassroots level. This is what we call devolution. be sure, the High Court did find that basic structure of the 2010 Constitution exists and is informed by our unique Kenyan experience. As my lead counsel had said, the final report of the Constitutional Review Commission stated, and I'll be very brief, because this is in page 124 of our submissions within the AG's record, that how can we protect the Constitution from a similar fate? There's need to protect the Constitution from indiscriminate amendments. And I'll end by this. This constitutional amendment bill is the death of the Constitution by 1,000 cuts. And in upholding the Superior Court's decision, this court might help our Constitution escape another 70 or 74 deadly cuts to the Constitution.
Thank you, Counsel. Thank you very much. We shall take a 20 minutes break, and we shall be back thereafter. Kanjama, are you here? Is Mr. Kanjama here?
He's allowed, he was here.
Okay. There is an application filed by him, and all we wanted to tell him is to serve it, because it has not been served. It was filed yesterday. We'll hear his appeal this afternoon. Now, if he's not here, we must proceed. Mr. Ongoya? Mr. Ongoya, please do your best to stick to the time.
Thank you so much, my lord.
Thank you.
My lords, my ladies, my name is Elisha Ongoya. I appear together with my learned colleague, Mr. Evans Ogada, for the 74th and 75th respondents in the lead file, that is Justus Juma and Isaac Ogola. Doing the best we can, I'll utilize 35 minutes of our 1 hour, and I'll cede 25 minutes to Mr. Ogada to make the remainder of our case. In terms of the documents that we desire that you look at, you will see our written submissions bound together with our authorities dated 23rd June 2021, a 523-page document. In addition to that, we'll also invite you to look at the petition that those two respondents filed in the High Court, which is E402 of 2020, that is to be found at page 1876 to page 1884 of the record of appeal in the lead file. We'll also ask you to look at the Attorney General's ground of opposition that were filed there at page 1944 to page 1946. Then we will draw your attention to the affidavit of Dennis Waweru that was filed in reply to that affidavit. And the same, I will draw your attention to the appeal by the Attorney General at page 2678 to page 2689. Time permitting, I'll make some specific reference to that affidavit. Otherwise, if time doesn't permit, I'll just go ahead and draw your attention to the paragraphs that I want you to look at. Finally, my lord, I will invite you to look at the judgment of the High Court that touches on the issues that were raised by those two petitioners, and you'll find those issues addressed at paragraphs 633 to paragraph 698 of the judgment. Having said that, my lord, and looking at the limitations of time that we suffer in the course of these proceedings, I would wish to draw your attention to a literature that is found in the American literature on the American Supreme Court, and the book is called Stories of the Supreme Court Law Clerks and Their Justices in Chambers. And drawing inspiration from that, I want to pose the question: when the heat and dust in this room has settled and you have retired in your chambers with your law clerks to conference, what conversations do these two respondents expect you to have? The first conversation that these two respondents expect you to have is a conversation on whether our Constitution has a basic structure. In making that conversation, my lords, these respondents expect you to have a look at paragraph 468 of the judgment of the High Court. When you look at paragraph 468 of the judgment of the High Court, you realize that contrary to the appellant's submission that was repeated severally, that the Superior Court judges somehow retreated to India, found some decision there, and brought it to Kenya hook, line, and sinker, the judges of the Superior Court did something very different. They discovered a basic structure that pre-exists in our Constitution by looking at the history, the text, and the structure of this Constitution. The fact that they made reference to some comparative learning is something not objectionable, is something praiseworthy, but it's important to note that they expressly took advantage of Kenya's history, Kenya's text, and Kenya's structure. In a way, my lords, I want you to reach an inevitable conclusion that the judges developed what is otherwise described as rich, indigenous jurisprudence. Rich, indigenous jurisprudence that takes into account our unique circumstances. While having that conversations with your law clerks in chambers by way of conferencing, I also want you to have a look at paragraph 457 of the judgment of the High Court. At that paragraph, you'll discover that the judges were inspired by a decision called Commission for the Implementation of the Constitution versus the National Assembly of Kenya and two others. 2013 EKLR. I would invite you, my lords, to fish that judgment and read it yourselves for its persuasive value, and you will discover the following things. One, the judge in that matter, Lord Justice Lenaola, now Judge of the Supreme Court of Kenya, was invited to find that the Constitution of Kenya has a basic structure, and he so found. He was invited to make that finding by Senior Counsel George Oraro, currently appearing for the Attorney General in this matter. He was invited to make that finding by the very learned counsel, Mr. Nyamodi, currently appearing for the Attorney General in this matter. I want to just cross-refer to the submissions by the very learned Senior Counsel, John Haminwa, as to whether people exactly spoke what they believed in when they took this podium. But we'll make that finding. At the end of it all, we'll invite you to find that indeed it is true that Kenya's unique history, Kenya's constitutional text, and Kenya's constitutional context has a basic structure. The second question, my lords, that I would invite you to have a conversation with your clerks in chambers when you retire from this heavy duty is to ask what exactly was the obligation of the High Court judges, and did they discharge that obligation in accordance with the prescribed rules or principles? The judges of the High Court, so far as the case of the 74th and 75th respondents are concerned, were invited to interpret the Constitution and to enforce rights. When judges are called upon to do that task, they exercise a jurisdiction that is prescribed in this Constitution and whose parameters is also supplied by the Constitution. For example, when they were called to enforce rights, they were subject to Article 20 of the Constitution that informed them that every person shall enjoy rights and fundamental freedoms to the greatest extent consistent with the nature of the rights and fundamental freedom. To the greatest extent. When the judges therefore say that we must secure citizen participation through first citizen information, civic information first, civic education as part of primary constituent power, constituent assembly, then you move on to the third stage, then you go to the referendum. Does that secure least enjoyment of rights, or does that ensure greatest enjoyment of rights? I submit, to the extent that inevitably you will find that that ensures maximum enjoyment of citizen participation, you must reach the inevitable conclusion that the judges had the correct approaches to the resolution of the dispute that was before them. The judges were then also obligated to utilize the guidance in Article 259 of the Constitution. Article 259 of the Constitution has a catalogue of many principles which in scholarly terms are summarized as a purposive approach to the interpretation of the Constitution. Once you read each of those elements in that catalogue, they are what we call a purposive approach to this Constitution. In applying the purposive approach, the judges delineated three powers that can be found in this Constitution: primary constituent power, secondary constituent power, and constituted power. The question I'll be asking is, isn't it true that if you read this Constitution, you actually discover those three powers? Article 1 yields such an interpretation. So you cannot fault the judge for the interpretation approach that they adopted in their resolution of this dispute. Allow me, before I deal very briefly with the direct question of the delimitation, distribution, and creation of constituencies, which bothered those two litigants now before you, to respond to some questions that my lords did raise yesterday. I think it was my Lord Justice Tuyot, you pardon me if I'm wrong, who asked a colleague of mine, learned counsel, the question whether in discovering whether an amendment is the same thing as a repeal, in reference to the Constitution, one can take recourse to the Interpretation and General Provisions Act. Thank you so much, my Lord. Our direct and straightforward answer to that question is that Section 2 of the Interpretations and General Provisions Act expressly prohibits you from taking recourse to that statute while interpreting the Constitution. It acknowledges that that statute has a definition of amendment in reference to statutes, But when it comes to the Constitution, it expressly bars you from using that one. That is an acknowledgement of what the respondents have been telling you here all along.
Sorry, Mr. Ongoya, that's important.
Yes, my lord.
You are saying that it expressly bars you from using that method to the Constitution? What is the wording of the statute?
The wording of, allow me just to put it this way, Section 2 of the Interpretations and General Provisions Act expressly says that that statute does not apply to the interpretation of the Constitution.
Does it say so in those words?
I need to...
That it doesn't apply to the Constitution? I mean, I just want to know that.
Yes, it says so in those express words. In fact, it says, for purposes of that statute, the Constitution is not written law. It says so expressly.
Okay.
Thank you so much, my lord.
That's Section 2?
Section 2 of the Interpretations and General Provisions Act.
Thank you.
Thank you, my lord. Having said that, there was a question raised by, I think, my lord Justice Kiage on the question of burden of proof, where a litigant comes to court and says there was no public participation. In fact, learned counsel stood here and audaciously told this court, the person who told the court like that there was no public participation, had an obligation to prove it. Allow me to deal with the commonsensical aspect, then go to the Evidence Act. Commonsensically, my lords and your clerks in chambers will have to deal with the following question. So how do you prove a negative? How do you prove a negative if you bear that burden? But more directly, I would ask my lords to then ask your clerks to have a clear reading of Section 109 of the Evidence Act, which provides that the burden of proof as to any particular fact lies in the person who wishes the court to believe in its existence. It is actually the appellants before you who wish you to believe that there was public participation, that public participation existed. By instrument of Section 109 of the Evidence Act, the burden of proof lay on them. I trust that I have at least attempted to give guidance, as I'm professionally bound, to what this court must consider in answering those questions. My lord, on the question of constituency creation, constituency allocation, and boundary delimitation, I would invite you to take a reading of paragraphs 442 to paragraph 657 of the judgment. When you do that, my lords, my ladies, you will discover that the court set out the history, our history of Article 89 of the Constitution on boundary delimitation. None of the appellants in their written submissions and none of the appellants in their oral submissions here have challenged specifically the historical account of the judges on Article 89 of the Constitution. It's important. Because, my lords, if Section 3 of the Supreme Court Act behoves the Supreme Court to develop rich indigenous jurisprudence, it follows that all courts beneath the Supreme Court must develop rich indigenous jurisprudence, because they are bound by Supreme Court edicts. So it can't be that the Supreme Court can develop rich indigenous jurisprudence as other courts develop pedantic jurisprudence. Having said that, the judges who have taken recourse to say an understanding of Article 89 of the Constitution must be understood from our history and our context cannot be faulted. So what is that context? When you read those paragraphs, the judges tell you that constituencies now are units of resource distribution. They say that in the judgment. judges, my lords, you live in this country, and that is a commonly notorious fact. National government, CDF, is a constituency function. Bursary funds, constituency allocated. Police recruitment, military recruitment, it's at the constituency level. And therefore, my lords, one of the greatest historical problems that this country has faced is the question of gerrymandering of constituents and their boundaries. The challenge is this, and I'm now posing the question my learned colleague Mudomithi Ankolu posed yesterday. If you interfere with the prescription by the judges of the High Court, you must ask yourself, what alternative prescription will you be proposing? Will you be proposing a prescription that allows allocation of constituencies in, to use Mr. Karori's words, political context, political way, politically, not legally, not scientifically, politically, with the net effect that you will be documented as the men and women who 100 years to come will be said to have led to skewed allocation of resources. Because once you find that the constituency now is a unit of allocation of resources, prescribing a formula that paves way for skewed distribution of constituencies, skews allocation of resources, and entrenches marginalization, contrary to the expectation of our constitution that we have to have equity and equality, and therefore the formula to be used must be scientific. The judges therefore found that the way Article 89 is prescribed, laying out a detailed scientific formula of identifying which constituency lies where, helps in dealing with that historical problem of gerrymandering and the potential consequences of marginalization, which the appellants now ask you to entrench by judicial edict. That would be a sad day in the history of the development of our jurisprudence. So that, my lords, you will ask yourself this question: is there anything constitutionally untenable in the judges having used the text of Article 89, the history of Article 89, and the context of Article 89 to interpret it? You must ask yourself that question. I beseech you, my lords, to find there is nothing wrong with that approach that was taken by the High Court judges. There is something I want you, my lords, to reflect on very pensively when you retire in your chambers, because your work here is a little more spiritual than it is human. I mean, you are dealing with a defining case in the history of a country, a case that 200 years later, like Marbury versus Madison, people will look back long after you and I are long gone. You must ask yourself, how come the entity in whose hands the power in Article 89 is vested, the IEBC, in their appeal before you, have not challenged the finding of the High Court relating to Article 89 of the Constitution? How come? I'll go back to what learned senior John Haminwa submitted here. There must be an inevitable conclusion that they don't believe the High Court was wrong in that interpretation. They don't believe that the High Court was wrong in that interpretation. I will encourage you to find as wrong the submissions by my learned colleague, Mr. Karori, that distribution of constituencies in this country is a political question and not a legal question. It is a legal question, number one. Number two, that legal question in terms of its proximity or presence within the basic framework of the Constitution must be construed taking into account the unique history of this country. The judges did that. They looked at the Kriegler report and what it says. And to use the words of Chinua Achebe, to disown that history of this country, you must be a very dishonest person. You must be a liar. You must be fraudulent to disown that history, because we were all here. We know how Kriegler happened. We know how it happened. To disown it, you must be irredeemably bad. Having said that, my Lord, allow me in the next couple of minutes to address an issue that arose again yesterday about the continuum of this amendment process. Learned Senior Counsel, very good friend, very good mentor of mine, Senior Counsel Otiende Amolo Paul, raised the issue of severing the process of the steering committee, the task force, and something called the secretariat. He said those were three distinct processes, and that when you retire, you must make that finding. When he made that submission, I was sitting far behind in this room, and I thought the judges must have had that in mind when somewhere in this judgment they say there's an attempt to amend this constitution by stealth. That we shall do it this way. When they ask us, we shall just say it is this way. Why do I say that, my lords? The person whom Paul Otiende Amolo wishes to convince you was the promoter of this bill swore affidavits in the High Court, and you were taken through those affidavits in detail. I wouldn't want to do that because I don't even have the luxury of time to do that. But just a brief aspect that I would pick is to be found at page 2678 of the record of appeal filed by the Honorable the Attorney General. So when you go to page 2678 of that record of appeal, you will find the affidavit of Dennis Waweru. That name featured yesterday, as I've said. Turning over leaf, Dennis Waweru told the High Court in a sworn affidavit that, paragraph 5, my lords, I'll not ask you to take verbatim this because it's not necessary to find the record, but for the full effect of my submission, I'll take you through it. That the building bridges to a united Kenya was created. Who created it? Was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other functions. That the Building Bridges Initiative Task Force and Secretariat, he now says they were one and the same functionaries, and Secretariat conducted a robust nationwide public engagement and collection of views on a wide array, including meeting professionals and professional bodies, among others. That upon receiving those views on various issues, it, which now refers to the Building Bridges to a United Kenya, same original entity, made various legislative, policy, and constitutional amendment proposals. Now, my lord, we are told to ignore this that we said on oath, that this was a continuum of a process. Because when you look at this judgment that is impugned, they are saying the judges of the High Court confused this to have been a continuum of a process. That's in a nutshell what they are saying. They themselves, on a sworn affidavit, are telling those same judges that same story, that this was a continuum, one continuous process on a sworn affidavit. And that's the person you are told that is actually the promoter. My lords, allow me to make one argument that my learned colleague, Ms. Angawa, made yesterday, and she asked me to cap it up because of the time constraint she suffered yesterday, that even if you, and I really celebrate the young, what we call young counsel who appeared here, because they have really proved that the future of the profession is safe. I must put that on record. Even if you are to believe my learned colleagues for the IEBC, that referendum in this context is governed by the Elections Act, even if you are to believe them, I'm sure following Ms. Angawa's submissions, they may consider departing from that position But even if you were to believe them, you then see that the obligations in the Elections Act are such that the National Assembly, when it is faced with an issue that is supposed to go to a referendum, has an obligation to approve one or more questions. One or more questions. So that, how does the National Assembly approve one or more questions? It must consider whether it is a question worth going for a referendum. There must be a thought process applied to it. And you'll see later, as she submitted yesterday, that where there are more questions, there shall be a referendum committee for each question. For each question. That's what the statute that the IEBC is calling upon you to follow says. It follows, therefore, that if the Parliament, for example, has to apply its mind to the question before it, the issue that somebody has to keep running to court to get an interpretation every time, then going to consider whether is it not, cannot arise. My lords, I will submit to you that Parliament, for example, the Speaker of the National Assembly by law is prohibited from allowing debate on a motion that is unconstitutional by law. The Speaker cannot allow debate on a motion that is unconstitutional. It behoves me that you have not seen speakers coming to courts to ask you, is this motion constitutional, my lords, before they go back to Parliament to conduct debates. It means, therefore, that there is an element of scaremongering in telling you that you'll be overburdened, my lords, that people will have to come here. Truth of the matter is that every person who intends to amend this constitution has an obligation to apply his own mind on whether the amendment he proposes affects the basic structure or not. To apply his or her mind. Once he applies his or her mind, he proceeds accordingly. If a vigilant citizen takes the view that the manner in which that person has applied his or her mind is wrong, it is that person who approaches to court to challenge the process, as has happened here. Courts will sometimes agree with such litigants. Court will sometimes disagree. So the argument that the judges here created a scenario where whoever wishes to amend the constitution must come to court does not pass muster. And I will submit to you by way of comparative reasoning that this applies in all spheres of our operations. I know for a fact that if I engage in a fraudulent land transaction, that land transaction will be nullified by the court. But that does not mean that people come to court to seek an interpretation first. Is this fraudulent or not? Before they engage in land transaction. They apply their mind to the question, to the principles first, then begin the process. It is whoever believes the process is fraudulent that comes to court. Allow me at this juncture, in our spirit of sharing time, to invite my learned colleague, Mr. Ogada, to pick over from there and do duty for the respective respondents. And thank you so much, my lords, for the opportunity.
Thank you.
Good morning, your lordships, your ladyships. I must start by paying homage to my seniors, ladies and gentlemen who have toiled and did service to the profession, though we sit on opposite sides. Particularly have to recognize the efforts and input of Senior Counsel George Oraro, decent gentleman in every sense of the word, Senior Counsel James Orengo, Gatonye, Martha Karua, all protocols observed, Alicia Ongoya. You have done well for us, and you have blazed the trail for us. In the spirit of recognition, I have to recognize my teacher, Professor Ben Mutembei Sihanya, who sits on the other side representing the Building Bridges Initiative, and the Honorable Raila Odinga. And I will recall Professor Sihanya for not only being a great teacher, but also for the manner in which he dispatched me to the world of the profession and into the world of work. This is what Professor Sihanya told me and my colleagues, ushering us into the world. Go ye, people of Jerusalem, as he called this, and speak the constitutional truth. Speak truth to power. Professor Sihanya, I can assure you that I am here to speak the truth, and I'll speak the constitutional truth to the following questions relating to boundary delimitation and review. The appellants have raised certain questions with regards to the decision of the High Court. And certain issues have been raised with regards to the people and sovereignty. Certain issues have been raised with regards to the authority of the High Court. And most particularly, there have been raised concerns with regards to public participation. Judge President Musinga, you posed a question yesterday. Who are the people? I will attempt to proffer an answer. The people as a constitutional construct, and indeed the term the people is a continuous theme under the Constitution. Where do we find the term the people under the Constitution? The preamble, paragraph 2, Article 1 of the Constitution, Article 94(1), Article 129, Subarticle 1, Article 159, Subarticle 1. That is not an exhaustive list, but those are the salient examples. Now, the term the people was bandied by the appellants to show that the court, the High Court that is, usurped a power belonging to the people. In doing that, the High Court was faulted for ignoring the popular initiative, an initiative of the people, under Article 257. And in any case, the High Court was faulted for stopping the people from accepting or rejecting the Constitutional Amendment Bill at a referendum. In examining the concept of the people, and we refer to the people at paragraph 2 of the preamble, Article 1, Article 94(1), 129(1), 159(1), we submit as follows: that the Constitution knows of a distinct and graduated schema of the term the people and or authority exercised by and on behalf of the people. We want to make reference to the following. Volume 7 of the Attorney General's list of authorities in appeal, at page 2645, contains the submissions of the respondents, Justice Juma and Isaac Ogola, in the High Court. And specifically, I want the courts to examine paragraph 21 of the main text, which is referenced in the footnote at paragraph 30 of the same page, a text entitled Yaniv Roznai Amendment Power, Constituent Power and Popular Sovereignty, Linking and Amendability and Amendment Procedures. This is in the edited text by Richard Albert, Zenon Contrades, and Alcamen Fatidu. That was by the respondents here, the petitioners in the High Court. That argument was so persuasive that the Attorney General decided to adopt it in appeal. And the Attorney General, at paragraph 44 of their submissions, adopts the graduated power scheme in the Constitution. What is this What did the Attorney General say at paragraph 24? For quick reference.
24 or 44?
44. It is the Attorney General's further submission, they said, that the people of Kenya, in the exercise of their secondary constituent power, are at liberty to amend the Constitution without resorting to the primary constituent power and provide changes, provided that changes are done in accordance with the provisions of Chapter 16 of the Constitution. What are the distinct and graduated schema the term the people denotes under our constitutional scheme? Primary constituent power. Paragraph 2 of the preamble. The primary constituent power is not bound by constitutional rules. It exists outside the constitutional rules. It acts only when enacting a new constitution. B, the people in the secondary constituent sense. The people acting to amend the constitution. The people acting in the course of an amendment process. Those are the people in the secondary constituent sense. Then we have a third tier, that is the constituted constitutional organs, where the people can be involved in terms of influencing decisions. So we have constituted organs as a place where the people can exercise their sovereignty. Constituted organs include the judiciary, the executive, and of course the legislature. Now, we have to make a connection between the people and the concept of sovereignty. Due to the urgency of time, the term sovereignty is understood as residing in the people exclusively. What is understood by sovereignty? Sovereignty manifests majorly in two forms. I want to refer to you in paragraph 2, in page 296 of the respondents' bundle of authorities, page 296, paragraph 224. There's an article there by Dieter Grimm, whereby sovereignty, first and foremost, is political rule. Supremacy, political rule. Sovereignty also can denote legal power. That is in the same book, paragraph 30. The power to create and implement a peaceful order. A peaceful order such as the Constitution. Having examined the concepts of the people and sovereignty, the key question is this: what is the significance of this term the appellants have put so much emphasis on? The referendum. We submit this, that the referendum is a tool of involving the people to affirm a decision or to influence a decision. It is in democratic theory called a mechanism for direct democracy. It affirms the process. The referendum, when used in the context of making a constitution, it will be exercised in the primary constituent power. However, a referendum exercised in the process of amending the constitution, such as in our case today, within this litigation, is going to be exercised within the secondary constituent power. That distinction is important for this, that whereas the court did not and cannot have authority to examine the primary power because it exists outside it, the referendum, questions relating to the referendum exercised in the secondary constituent sense are examinable by the court. Quickly, we then move to how the sovereignty, the concept of sovereignty, reveals in the Constitution. And we have provided two articles, Dietmar Green and Daniel Lee, in our bundle of authorities. Dietmar Green explains sovereignty, political rule, legal rule. Daniel Lee explains sovereignty as popular sovereignty. Popular sovereignty means this, that sovereignty in the practical sense is channeled through constitution, through constituted organs. So sovereignty can be channeled through the judiciary, the executive, parliament, and that is bona fide power exercised for the people. So when the judiciary exercises sovereignty delegated to it by the people, it acts bona fide. And the same is true for the IEBC, that at Article 249, is expected to express sovereignty on behalf of the people. And let this message be clear out there, that the IEBC is an independent, bona fide recipient of the sovereign power of the people, and only responds to the people, and acts in authority as granted by the Constitution to nobody else. Quickly, I move to the authority of the court. There's a growing habit in this country. Senior Counsel James Orengo made an allegory of Jezebel. Jezebels in this country have had the habit of every time judicial officers make judicial decisions in accordance with the Constitution, the Jezebels will go call judicial officers' names, deprecate their image, all in the name and in the belief that the judiciary is a lesser branch of government, that the elected branches purportedly have higher status than the judiciary. What is the authority of the High Court and indeed the judiciary under the Constitution? We have established already that the judiciary is a direct beneficiary of sovereign authority. That is not controvertible. The Constitution enables the court to be a situation, a site for sovereignty of the people. Chapter 10, Article 159(1) employs the term vests. This term vests was only used in the Constitution in reference to the judiciary and to the legislature at Article 94(1). Ask yourself, when it comes to the executive, the term vest is not used. What is the message that the drafters of the Constitution were sending to us? And what does the term vest mean? The term vests under the Black's Law Dictionary refers to this: conferring ownership, to invest in a person, full title or property. It can also mean an immediate fixed right. So, ladies and gentlemen, the Honorable Court, the judiciary is vested with property. You are agents of the people, and you have to speak the constitutional truth without fear, favor, or feeling intimidated. You are bona fide claimants of sovereign authority. The High Court, as structured in the Constitution, loosely adopts what is called the Kelsenian court in conceptual theory. Professor Gidu Muigai submitted here that the High Court engaged in lofty theory. Theory in constitutional law is part of the footstools, the African stool. Theory is one of the footstools that anchors the law. The law is anchored on the who, the what, the why. The who, substantive law. The what, substantive law. The why, theoretical law. The how, procedural law. So theory. The Constitutional Court, Kelsenian Court as it's commonly called, is a product of histories around the world. The Kelsenian Court, such as our loose model in Kenya, is equipped with a special unique power, the power of judicial review. And that power is ably pronounced at Article 165(3). And that is the authority that the court claimed when it examined the substantive values of the Constitution in the impugned bill and the procedural steps because the court is empowered to examine substantive questions, the value questions, and the procedural steps, the procedural values of the Constitution. And Article 165(3)(d)(2), I hope I'm correct, any threat to the Constitution is enough to invoke the authority of the Kelsenian Court, as the High Court did, in drawing from the sovereign authority it receives from the people. The High Court exercised bona fide authority. That is the authority granted to it under the Constitution. And therefore, it is demeaning, it is a tad arrogant to cast aspersion on judicial officers, to demean the image and integrity of courts for specifically doing what is decreed and declared in the Constitution. We submit a Kelsenian court, the High Court, enjoying the Kelsenian prominence loosely as it is in the Constitution, is a bona fide recipient of sovereign authority from the people of Kenya. Quickly, I move to public participation in the context of constituency and boundary delimitation. We have provided material in our bundle of authorities at page 428 to 429, and this is a scholarly article by Professor Tina Nabachi and Matt Liniger, Public Participation for the 21st Century. A lot has been said about public participation, but this was not said. Public participation enjoys its pride of place at Article 10. And Article 10 deals with principles and or values of the Constitution. Now, what is public participation? This is our submission, that public participation is a differentiated power track. What do I mean by a differentiated power track? It is authority belonging to the people, sui generis, and must be exercised in its quantitative and qualitative sense, and that is without apology. Public participation simply denotes that the people, in their sovereign superiority, must influence, must have input in important matters of their governance. Public participation in the context of constituency boundary delimitation ought to have led to the question with regards to Article 89(1). Do we keep the constituencies at 290, or do we reduce them? We are burdened by loans taken from all over. The burden is too much for us. Can we reduce the number of constituencies? That is a question that the people of Kenya should have borne, if the question was posed to them. The people of Kenya, in their madness or cleverness, could also have decided to increase the number to 400. That question was not posed to them. And we have submitted that public participation in the context of boundary review and delimitation did not happen. Telepathically, I can hear a question that he who proves, he who alleges must prove. My senior Elisha Ngoya addressed the commonsensical and the legal bits of it through the Election Act. I want to answer it in the political sense and drawing from authority from this court. In the political sense, being that we are citizens and not subjects. The citizens of Kenya, Nafula from Trans Nzoia, Mwekali from Machakos, Auma from Uyomararieda, Wajiko from Nyeri, ought to have been asked about whether they want to increase or decrease the constituencies under Article 89(1). So we allege that did not happen. Now, to those who will tell us that since we are alleging we have to prove that public participation did not happen, allow me to refer you to an authority of this court, Civil Appeal number 6 of 2018, the case of Kesi Jindwa Karuku versus Steelmakers. This court said that a negative inference such as we are making cannot be on us to prove. It is for those we are citing that negative inference to certify this court that indeed public participation did happen. It did not. As I wind up, and in conclusion, one Kenyan who unfortunately demised, and Kenyans quite clearly remember him, the late senator for Mutembei, one Gerald Otieno Kajwang, contributing to the Bomas Revolution Committee, said this: "We are the people. We must disperse power. We must share resources. We have to spread power horizontally and vertically." Quite animated as he was, that is the message of this constitution. Power has to be deconcentrated from the center. The people have to have their share of power as they envisaged under the constitution. Public participation being one track of authority as we declared and decreed unto ourselves. Another Gabriel, and this is Gabriel de Riquetti Comte de Mirabeau. This is a French legislator in the context of the ousting of King Louis XVI, a despot par excellence during the French Revolution. Told this to the military guards who were sent to come and disrupt the Constituent Assembly. I will say it in French and I will translate it in English. Allez dire au roi que nous sommes ici par la volonté du peuple et que nous n'en sortirons que la force du bayonet. For those who don't understand French, basically what Gabriel de Riquetti, Comte de Mirabeau, said is this: that go tell your master, your king, that we are here by the will of the people and we will only be forced out by the force of the bayonet. That's an exhortation for this honorable court. Mudomi Thiankolu, addressing you yesterday, told you not to drop the sword. When that sword was dropped, we had the radical surgery where judicial officers were treated inhumanely and demeaned for extraneous reasons. The tenure of the judges was removed for extraneous reasons. The constitution was reduced to blanket piece of papers. Gazeti tu ya kusoma. That is what we hear them say. This constitution represents the solemn will of the people of Kenya. This constitution was inked in blood. This is a product of a constitutional moment. 2007, when people died, killed, mercilessly butchered. That led to this constitution being and coming into life. It cannot be, as has been suggested from other quarters, that this is an elite pact. Hell no. This is a product of blood and sweat of ordinary Kenyans. I end by saying this to the Honorable Court, and in echoing the words of a very noble son of Africa, Deputy Chief Justice Emeritus of South Africa, an admirable man, Digang Moseneke, the courage of principle. You have to have courage. The principle is in this constitution. Take fortitude in what it says. Courage, principle, adherence to our constitutional pre-commitments. Those are the only saving lines for us not to drop the sword. The insults will come, the calumny will come, the indignity will come. But to you and for the people of Kenya, it behoves you to do one and one only thing: pre-commitment to the Constitution, and that alone will suffice. I submit. Thank you.
Thank you, Council. Who's next?
May it please the court. My name is Kevin Doho Masharia. I appear with Edgar Busiega for the...
Is it Kevin Macharia?
Yes, Kevin Doho Masharia. I appear with Edgar Busiega for the Kenya National Union of Nurses. Our petition in the lower court was petition number 397.
Sorry, you say you appear together with Mr. Busiega?
Yes, Edgar Busiega.
And remember we're given 15 minutes. Thank you. Thank you.
Yes, I'll try.
Thank you.
Because of the little time, the 15 minutes, I'll just highlight the documents, and Mr. Busiega will highlight the cross-appeal and the issues arising out of the betrayal of the legitimate expectation of healthcare workers. We filed a notice of address and a notice of cross-appeal.
Counsel, can you try and raise your voice, please?
Yes. We filed a notice of address and a notice of cross-appeal dated 8th June 2021. We then filed submissions dated 9th June 2021, a list and digest of authorities dated 27th June 2021, plus additions in volumes A, B, and C. Then we relied on the petition and submissions from the lower court found on the BBI record from pages 1257 to 1353, and our issues in the lower court judgment were addressed from paragraphs 620 to paragraphs 632. We had annexures which are found on volume 3, paragraphs, page 1313 of the BBI record of appeal, and the gazette notices at volume 4 of the BBI record of appeal at between pages 1574 and 1576. The position of our client is we oppose the BBI bill only as far as it excluded the Independent Health Commission as found to be found as a constitutional amendment. I'll give a few comments before I sit down. On the basic structure, we submit that the Constitution does not contemplate eternity clauses. We rely on an authority called Dead Hand Constitutionalism, Honduras, and the danger.
Counsel,
yes.
Let me understand you. You are, other than for the part where the learned judges did not agree that you ought to have been included in the amendments.
Yes.
In actual fact, you are actually opposed. No, you are supporting the appeals.
Yes, somehow.
What do you mean somehow?
Because when we want that health commission, the Constitution must be amended to include the interests of the health.
I'm looking at your prayers.
Yes.
Your prayers are at page 2 of your notice of cross appeal, and you're saying that you want the judgment delivered on 13th to be set aside, the entire judgment be set aside, and
the petition to be allowed.
And your petition be allowed.
Yes. That's as far as we go.
So
that's as far as our submissions go.
So you are supporting the appeals?
We are sui generis litigants. We only have one issue to prosecute and find a way to find the interests of our clients provided for.
So perhaps don't go into the basic structure and such a thing. Just go straight to your issue of that you should have been included.
We have to, because if basic structure applies, our client will not have a way to get what they want.
Oh, okay.
Yes.
Sorry, how does then basic structure have to do with what Kenya National Union of Nurses want?
What we say,
one singular issue.
Yeah, what we say is this: the constitution is amendable, and it can take into account the healthcare issues, especially the interests of our client. Because of the shortness of time, my colleague will deal with those issues. Yes, Mr. Busiaga.
And that's why, of course, it's too late now. Ideally, you should have come earlier to support this whole business of the appeal.
He'll deal with those issues, especially on that issue.
Just a moment, Council. Yes. That you should have come earlier. It's more sense for us, in terms of where our head is, what we are focusing on now.
Yes.
I guess it's your time.
Okay. From that aspect of what you're asking, we adopt our submissions and we ask that you give them credence to our prayers. And because of time, I just promised my colleague that I'll take 3 minutes. My 3 minutes are up. I rest.
Thank you, Your Lordships. My name is Edgar Busiaga, for the record. In the interest of time, I'll submit without necessarily referring to documents. Perhaps for the bench to understand the issue at hand and the position of the Kenya National Union of Nurses is that the Constitutional Amendment Bill of 2020 is opposed. Your Lordships, it is opposed to the extent that the nurses were not made part of the process. And what was choreographed as a public exercise in terms of seeking public views, in which the nurses presented their proposal, that proposal was ignored. Your Lordship, it was admitted in the first report, which is popularly known as the BBI report 2019. But subsequently, when the amendment bill came through, it was not part of it. To that extent, therefore, we oppose the Constitutional Amendment Bill and state that it is actually a legal fraud. A legal fraud in the sense that it does not represent the wishes of the people. My lords, the nurses were made to believe that this was a process towards uniting the whole country. And they went ahead and told people, bring your views. Now, we are being told, and that submission was made by Senior Counsel Otienda Molo, that the promoters of the bill are one Dennis Waweru and Junet Mohammed. The nurses feel cheated to the extent that the promoters of the bill, to the best of their knowledge, was the President of the Republic of Kenya. And since the nurses were willing to be part of building a country, they subjected themselves to this process. Along the way, it turned out to be a farce, not intended to achieve the will and wishes of the people, but as a vehicle to serve their own private interests. In this case, the interests of the President of the Republic of Kenya and his erstwhile foe and now friend and brother, Honorable Raila Amolo Odinga. To that extent, we oppose the Constitutional Amendment Bill. If the process had been initiated with the inclusion of the Health Service Commission, an independent health service commission, with the same status such as the Judicial Service Commission, the Teachers Service Commission, the nurses would have thought about it. The eminent submissions I've had is that the appellants want the reggae to stop from where it was paused by the High Court. We cannot allow that. We cannot be taken for a ride. The Constitution Amendment Bill does not represent the wishes of the people. Now, I'll address the element of legitimate expectation as argued in our documents. Your Lordships, the cornerstone of legitimate expectation arises from a considered assurance in this manner. Nurses, bring your views, we look at them. We presented a memorandum for the Independent Health Service Commission. In essence, it was to cater for the human resource element and to liberate the healthcare workers from the arms of the governors, the county government. We have seen the turmoil in the health sector in this country. So we had subjected ourselves to this process to the extent that let's build this country together by reducing the numerous strikes. Let the nurses, let the healthcare workers manage themselves in terms of the human resource element. Let them take charge of their recruitment, disciplinary issues, and etc. Now, this proposal was considered and indeed brought out in the first BBI report. To that extent, it is our submission that constituted a promise. A promise upon which the nurses had a belief that there will be an independent health service commission. That promise could only be taken away through a procedural process. And the procedural process here is captured under Article 47 of the Constitution of Kenya. The nurses were entitled to be heard, to be subjected to a process of being heard and being given reasons why their document, their proposal had been omitted. The reasons given were that there were opposing views. Where these opposing views, they were never attached. Section 112 of the Evidence Act captures this position. They had the responsibility to bring this evidence. There are no opposing views, and therefore this whole process was all meant to mislead the healthcare workers. To that end, I seek your findings that the Constitution Amendment Bill 2020, as approved, passed through the assemblies and the two houses, is unconstitutional. And if this court will be minded at the end of it all, and that we leave it to your discretion, to find that the process is legal, then the healthcare workers must be included as part of it. That is our submission, unless there's any question from the bench.
I don't think there is. Thank you very much.
Thank you.
Can we move to no. Yes. Yes. Thank you. Thank you, Mr. Busiega, for using your time well. Mr. Chair Dudley, you have 30 minutes.
Thank you, my lord. My Lord, I draw your attention to our grounds of affirmation of 9th of June, our submissions of 23rd of June, our submissions replying to the county assemblies on the question of popular initiative of 26th of June, and to volume 1 and 2 of our case digest of the 28th of June. We filed also one supplementary case list on the 29th of June and one bundle of undated authority replying to the views of amicus on the 30th of June. My Lord, for the appellants to win, the court must do 4 things. 1, adopt textualism as a method of interpreting the Constitution and answering the issues in this appeal. Basically, the appellants are telling the court that as long as you follow Article 255 to 257, you can invade, deconstitute, replace, and alter any part of the Constitution without reference to the primary constituent power. Secondly, the court must elevate political elites above the people, which people hold the constituent power, and only they can make or unmake the Constitution. I say that because, my Lord, the Attorney General and BBI tell you that the Constitution was made by political elites, and they do that relying on the 2008 Act. That Act, from its long object, was to complete the process of making of the Constitution. It didn't start there. It started with the 1997 Act, the Constitution of Kenya Review Act of 1997, which we've supplied, my Lord, in our supplementary case list. I request the court to turn to that act and to look at its long title, my Lord, which was an act of parliament to facilitate the comprehensive review of the Constitution by the people of Kenya and its eventual alteration by parliament. My Lord, that act, far back in 1997, recognized the constituent power. How then can we unknow what we knew in 1997? That only the people can make fundamental changes to the Constitution. My Lord, you are told that no constituent assembly was formed. But if you look at Section 2B of that Act, you find the constituent assemblies. 2002, they were formed at the district level, and there was the Bomas Conference which happened. And so, my Lord, for the appellants to win, you must ignore that history, that the people were at the center of the process of making the Constitution and exercising their constituent power. And if you look at the guiding principles in that act, my Lord, they were again consistent with the people's constituent power, saying that it was meant to provide the people of Kenya with an opportunity to actively, freely, and meaningfully participate in generating and debating proposals, this is important, to alter the Constitution. Constituent power, Constitution-making power, the original power, not the derivative power, which reposes in 255 and 257. Well, the third thing you must do, and this is the last, is to upset a settled theory in comparative constitutional law, the theory of constitutional change. That theory, my Lord, in a word, is to the extent that the power to amend the Constitution is not the power to annihilate it. And my Lord, before I come to the bulk of that, the Attorney General accepts Yaniv to be an authority. Senior Counsel George Oraro told you so. Then when the court asked Senior Counsel about the familiarity between India and Kenya, that was Justice Musinga, if I remember, Senior Counsel's response was, there's no similarity. Yaniv, at page 42, records the answer to be as follows: that India was faced with far-reaching attempts by Prime Minister Indira Gandhi to amend its constitution. We have before you 78 missiles directed at the heart of our constitution. Yaniv, page 42. That is the context in which the Indian courts applied the basic structure doctrine. My Lord, the Indian court was not even the founder of that doctrine. They applied what Carl Schmitt had long spoken about. My Lord, in his book on the theory of the Constitution, which we've supplied to the court, you'll find Schmitt saying that the Constitution does not make itself. It is made by a higher power. That is the constituent power. And that is at page 559 of volume 2 of our record of appeal. Then he also says, my Lord, that changing the Constitution is not a normal state function, like establishing statutes, conducting trials, or undertaking administrative tasks. It is an extraordinary authority. It is an authority that belongs to the people. Senior Counsel James Orengo, who inspired many of us, including myself, to the law, left me confused. He posed the question, can the people exist outside the Constitution? The answer is yes. The people make the Constitution. Exercising their sovereign power and sitting as a constituent assembly, yes, they can alter the Constitution. They can change this country into a monarchy. And they can reorganize our modes of government. My Lord, Schmitt tells us on page 559, the last paragraph, that the authority to make amendments, I quote, contains only the authority to undertake changes, additions, extensions, deletions, etc., and that it is not the authority to annihilate the Constitution. In other words, you cannot use that power to make a new Constitution. And so that I move from Schmitt to someone else, my Lord, if you look at page 545 of volume 2 of our case digest, you will find Schmitt telling us that a constitutional law is the enabling legislation of the constitution-making will, and that it contains in it all that you need, so that if additional individual norms are written into the Constitution, that only has a technical, juristic meaning. The constituent power does not have to be written into the text of the Constitution. And that disabuses the views of Fombard, who tells you that because Article 255 and 257 do not contain the words Constituent Assembly or Basic Structure Doctrine, they cannot be invoked by the court. My Lord, did Kenyans intend that this constitution, like the current one, could be replaced, abrogated, altered gradually by amendment? I urge you, my Lord, to look at your screens for a moment and let us see also why the High Court's finding that the inquiry is factual makes sense. Kindly show us amendment number 7. My Lord, this is from page 1150 of the Attorney General's Record of Appeal, Volume 3.
So we may not be able to read it from here, but sorry, are you able to just refer to where it is from, so that we can follow?
That's okay, my Lord.
Which volume?
Volume 3.
Volume 3
of the Attorney General's Record of Appeal.
Record of Appeal.
Page 1150. If it could be turned over to the court, I would be grateful. My Lord.
Can you have the volume? Yes, continue as they get it.
Thank you, my Lord. My Lord, amendment number 7, for example, of Kenya's constitution gave the president the power to order detention without trial, to prohibit any meeting, procession of society, to impose censorship, to impose curfews, and to draft anyone into the disciplined forces, including the NYS. That amendment touched the basic structure of the Constitution. It did. The second amendment, which turned Kenya from having a prime minister to a president, also went to the basic structure of the Constitution. And the one which deleted the counties, then we call them regions, also touched the basic structure of the Constitution.
Number 7.
Amendment number 7, my Lord.
Then just refer to the numbers in the interest of time.
Thank you, my Lord. My Lord, there's also amendment number 14, which made Kiswahili the only language in the National Assembly. That's an amendment because it is consistent with the body of the Constitution. It does not make fundamental changes. And moving forward, if you move to the further pages, my Lord, you'll find some of the attempts to amend the current Constitution. And you find proposals, for example, to deny the High Court jurisdiction over questions pending in Parliament. An amendment touching on the High Court's jurisdiction is an amendment touching on the basic structure. And so, my Lord, this inquiry must be factual. You must wait for the amendment to come before you, look at it, look at the body of the Constitution, its language, and decide if or not that amendment affects the body, affects the basic structure. There is an argument that the counsel who preceded me has made about the dead hand claim, that by imposing strict rules on constitutional amendment, we'll be tying the hands of future generations. That is not a new argument. It's an argument that Fombard also makes, my Lord. The answer to that argument is found at page 4 to 5 of Yaniv Rosnai. In justifying the amendment rules, he looks at both sides. Yes, the Constitution must be flexible, but it is not amended the same way as a statute, a fact that Parliament knows. And that is why the Interpretation and General Provisions Act does not apply to the Constitution. The Act recognizes its own insufficiency. It tells you, don't look at us when it comes to constitutional interpretation questions, including amendment. And my Lord, the Constitution cannot provide for its own repeal. No Constitution provides for its own death. And so special rules apply. Hans Kelsen, which you will find quoted at page 39 to 40 of Richard Albert's book, which is the supplementary authority we supplied to you in response to the amici, tells us that because the Constitution is the grand norm, it's at the base of the national legal order, it is desirable to give it a more stable character. And so, my Lord, special rules apply to the amendment of the Constitution. These rules can be written, like in Article 255 to 257. They can also be implicit, discoverable by reading the Constitution holistically. My Lord, if it were not so, can we say that if you get the numbers and follow the procedure in 255 to 257, you can come one day and delete the judiciary or deny it its independence? It has happened before. I do not speak in the abstract. Can we say that as long as you get the numbers, 1 million signatures, get people who are sufficiently angry with the counties, you can come and delete the chapter on devolution? It has happened before. Can we say that as long as you follow 255 to 257, you can come and kill the Senate? It has happened before. All the amendments, each one of them that killed Kenya's constitution, followed the procedure. Each one of them. In fact, at times, the threshold was lowered to make it easy for amendments to pass. Some passed in a single afternoon. My Lord, imagine being detained without trial because the Constitution has ordered it. Where does one turn to? And so the Constitution must have a higher place than ordinary legislation. The mistake that my friend Mr. Paul Mwangi makes is focusing on India as the origin of this doctrine. My Lord, while they see, I quote, a doctrine of a highly doubtful origin, rejected, again I quote, by a vast majority of scholars, a vast majority of courts, and which is repudiated by an overwhelming number of scholars, Yaniv Rosnai sees a growing trend towards adopting this doctrine. That is Yaniv at page 70. And Richard Albert, another authority in this area, whose work you will find in our authority replying to amici submissions, also sees the same trend. Richard Albert, you'll find it in volume 1. Sorry, you'll find that in Richard Albert's book, where this has gone to Belize and the Czech Republic, Latin America, my Lord, Asia, Africa. It's no longer an Indian doctrine. It never was to begin with. Carl Schmitt was not even Indian anyway. And Paul Mwangi cited to you Professor Upendra Baxi as dissuading you against applying this doctrine. I wish he cited to you what Upendra has recently said about this judgment, David D. in his article, Hooks, Pillars and Foundations. He finds that it's a legitimate doctrine and the Kenyan High Court placed the people at the center of the Constitution, unlike Senior Counsel James Orengo. My Lord, that doctrine is so theoretically sound that the the Kenyan judiciary has already held that the basic structure doctrine binds it in interpreting the Constitution. You find that at the CCK case, para 362, where the Supreme Court says, and I quote, the Kenyan Constitution sets to the judiciary, my lords, its barricade against destruction of its values and weakening of its institutions by forces external to itself. Also look at the Martha Kerubo case, which supplies the various names to these doctrines. My Lord, even if the appellants block you from applying what they are calling the basic structure doctrine, what about the Colombian constitutional replacement doctrine, which applies to the same theory, the theory of constitutional change? The power to amend is not the power to repeal or to destroy. My Lord, at page 215 of Yaniv, you'll find Yaniv saying that the Constitution's language is not just the explicit language, it's also contextual, because the Constitution has a history. And that's something the Supreme Court explains in Speaker of the Senate. It says that the Constitution is a document of compromise, Speaker of the Senate, para 156, and so that compromise facilitates ambiguities, vagueness, and gaps in phraseology. But constitution making does not end at promulgation. It continues with interpretation. And so you have the chance before you to make or unmake the Constitution. My Lord, to allow the appellants to win, you'd also have to disregard all modern constitutional law comparativists. Paul Geniap, we've supplied you with Hawak, Hannah Lena, David Landau, Rosalind Dixon, Mark Tashnet, all modern comparativists, because their work support the High Court judgment. I move briefly, my Lord, to the question of presidential immunity. And my Lord, the President does not enjoy absolute immunity. If he did, for example, under Article 143.3, the President can be sued after he leaves office. It freezes time from running. 143.3. What sense would it make to sue the President after he leaves office for official acts? Why would we bother a retiree after he leaves office? And so in short, Article 143.3 must be interpreted holistically, that's one, as the High Court has done recently in Katiba Institute, a case I was privileged to argue against Senior Counsel Waweru Gatonye. The President, on being sued for failing to appoint the 41 judges, raised a preliminary objection urging his absolute immunity from all processes. The High Court overshot that. We ask you also to do the same. Number two, there's no single president that from any country in the world that gives the President absolute immunity. President's Counsel could only rely on Nixon versus Fitzgerald. But Nixon versus Fitzgerald had different facts. It was a claim for damages for unfair termination. It was not a public law claim like the one before you. So it does not support, it helps us. And if you look at it, my Lord, you'll find phrases like private lawsuits, damages, liability for damages. It prevents private lawsuits. And the reason in Kenya is because of 165. Anything done or said to be done under the Constitution falls within the jurisdiction of the High Court. My Lord, lastly, as I yield the floor to my learned friend Mr. Ian Madenge, is that presidents have routinely been sued around the world for public wrongs. President Trump 2 years ago, President Jacob Zuma recently sentenced to contempt. And my Lord, if anything, and I say this with a lot of respect, the current president has shown us why a president must not have absolute immunity from all proceedings, especially those ones touching on the Constitution. My Lord, I rest my submissions and request you to call my colleague, Mr. Ian Madenge, to the podium. Thank you, my Lord.
Thank you, Mr. Chair. 10 minutes, Mr. Madenge.
Yes, Good afternoon, my lords.
Good afternoon, Mr. Mutembei.
Let me start from where my colleague has left by assisting the court on two issues. The first issue, my lord, is whether the text of the Constitution supports basic structure. And I will be making two arguments, my lord. The first argument is that the text of the Constitution indeed supports the basic structure. And to illustrate this, that the Constitution has a core content. There is no Constitution without a core content. Number two, my lord, is that the Constitution has foundational and prior principles. And I will demonstrate it to you, my lord, and my lady.
Foundational
and prior principles. Okay. What we call immutable principles in constitutional law.
Yes.
To demonstrate that, my lord, is Article 4.1 of the Constitution. 4.1 indicates that Kenya is a sovereign republic. It just declares the state of Kenya. It does not in any way grant Kenya sovereignty. That can be contrasted, my lord, with Article 156.1, which establishes the Attorney General. Number two, my lord, even more important and revealing is Article 4.2. It provides that Kenya is a multi-party republic founded on national value. So the foundation of Kenya and the Constitution is indicated in Article 4.2. That is what we call the value system of the country. You find it there. If you change that, you are replacing the Constitution. That is the value system expressly provided. And one claim, my lord, that I think will not be controverted is inherent nature of human rights. You find it in Article 19.1 and 19.3. Inherent nature. It indicates that that is prior. It is immutable. The Constitution does not grant it. It cannot change that. I will not go on, my lord, to discuss what was discussed on the issue of Kasevananda, but there is a misrepresentation. The High Court did not follow Kasevananda, line, hook, and sinker. It adopted it to our situation. Kasevananda said you cannot amend. The High Court says you can amend using the 4 steps which call in the constituent power. I left that point there and move to the second point, which is even more important, my lord. The second point, my lord, you are told that the president is the one who promoted the popular initiative. I will not delve into that. The question that I'll seek to answer, can the president promote? And to answer that question, my lord, I'll refer you to authority number 78. Authority number 78, that is volume 2, page 677 and 673. It defines what is popular initiative. We provide an authoritative definition of popular initiative in 673 to mean the rights of the people, and the key word in both is the people, my lord.
You say page 677.
677 and 673. 677 is paragraph 4. My lord, then that takes me to my 3 arguments why the president cannot initiate popular initiative. The first one, my lord, and I hope I'm not too fast, it's only the time that is harassing me.
Yes, proceed.
Number 1, my lord, is that the president has no power in the Constitution to initiate popular initiative. I have looked at the entire chapter 9, my lord, of the Constitution, and in particular articles 131, 132, and 133, which provides for the powers of the president in extensive manner. and expressly so. None involves amendment of the Constitution. I contrasted it with the previous Constitution, my Lord, that was repealed, and in particular Section 423 and Chapter 2. The President's power were very narrow. This time we provided them extensively, and none involves amendment of the Constitution. So the framers of the Constitution